to use this information, but if you do need to activate a grievance process, then you are really competent with the knowledge that how you need to proceed with activating this process. I'd like to welcome Naomi Bakamako. Now, the English way, we would say is wage maker. And in her line of work, that's actually such an appropriate word. But Naomi, thank you again for coming to discuss this with the whole HEADS team.
Thank you.
You're going to find this useful for the future.
Thank you so much. Thank you so much. You guys don't mind if I sit down? Okay. It's unfair for you to sit down and I have to stand and do all the work here today. Good morning, everybody. As indicated, my name is Naomi Wagenmaker. I'm from Employee Relations. I'm one of the Employee Relations practitioners. We form part of Human Resources and Transformation. I think a big part of why I was invited here today was I was requested to make a presentation at the ALP. I think it was in March. And colleagues, the first thing I did at that ALP is I asked the line managers, are your employees aware that we have got a disciplinary code and procedure and a grievance procedure? And secondly, if they are aware, did they hear that from you or did they hear that from the unions? Colleagues, these agreements were signed already in 2013. So I hope all of you have seen it before, but if you haven't, I hope there's an attendance register, so after today everybody's clear of what your rights and obligations are in this university. We received a few complaints at the ALP. We heard about cases where people were on sabbatical leave for 8-9 months. They came back, they never completed their degrees. Line managers did nothing about that. What I told the line managers at the ALP is, if we find that there's discrepancies in your department and you are doing nothing about it, we will not come to you and ask for an explanation. We'll go to your line manager and indicate to him what's the problem. This is our university. It's our kids' university. It's time we take it back, and it's time that we start everybody work together so that we make it a better place. So with that being said, even if you forget anything else that I'm going to tell you today, there's two things that I please hope you will remember. Firstly, always be hard on standards but soft on people. Very important thing that I learned from Commissioner Abel Venter, who he assisted us in, I think it was 2011, in the Blitz process. Soft on people but hard on standards. We cannot let our standards go down the drain. But there's ways to go about it. There's ways to talk to people. We need to respect each other. You know, and the second thing that I want you to please remember is do to other people what you would like other people to do to you. If you are an employee or a line manager, colleagues, really, if you don't like each other, fake it until you make it. Okay, so just quickly an outline of how this is going to proceed. I would like to go through the disciplinary code and the procedure, and after that through the grievance procedure. If you've got any questions, please ask them as we go through the process. Keep your difficult questions for afterwards on one-on-one sessions, but please ask your questions as we go through, because I don't want you to forget. And this is a very important session, and it's important that you ask and that we communicate and we talk about stuff. If anything's unclear, you must stop me so that we can proceed. Okay, and then we'll discuss that. Any questions before we start? Okay. As I indicated, there's two processes. We've got the disciplinary code, and we've got the procedure, and we've got the grievance procedure. An employee cannot instigate disciplinary action against a fellow employee. Okay. Discipline, it's a line management function. If you are aggrieved about something someone else did, you follow the grievance procedure. Grievance is sideways, discipline is from top to bottom. Okay. And even if you've got the problem with your line manager, you follow the grievance procedure, but managers must discipline their staff downwards. The purpose of this is not to tell you we are going to police you and you must now watch out, because everything you do, you know, there will be trouble and problems. The thing is, we've got this code, and one of the things that we need to prove at the CCMA is that these codes and discipline were we applied it consistently. So what you do in HEADS, they need to do at the Faculty of Humanities, they need to do at the Faculty of Arts, and administrative staff. Everybody must follow the same principles. If you dismiss someone for sexual harassment in HEADS, Then you hear about a case of where someone only received a final written warning in the Faculty of Engineering. That creates a major problem for us at Employee Relations when we go to CCMA with matters. And I told the line managers at the ALP, don't think I'm going there alone. Okay, so don't think that for 1 second. You will march with us all the way to CCMA, and if you messed up, you must come and explain. I'm not there to fix messes, no, really, really. So it's time that we start doing what we are expected to do. And it's not ER's responsibility to manage staff. I'm not here to go and manage your staff, I'm sorry. If you can't manage your staff, then please tell me, and then you give take away a piece of your post level because you get money for managing staff. So if you can't do that, then we'll have to deal with that in terms of the policies. Right. The reason why I'm saying that is that people, when they see employee relations, they say, oh, this one wants to dismiss me. Oh, this one wants me out of the system. It's not us. I couldn't care less if you work here or not, as long as you're doing the job and the university is at a better place. Okay, so please, colleagues, we are, at Employee Relations, we are here to assist both managers and employees. While a case is still internal, I will advise both parties, and I'm going to tell you straight, listen, you don't have a case, or yes, you do, let us address this appropriately. And I've worked with a lot of people that's sitting here in the past, and I think they will tell you that is our role, that is what we are here to do. I'm not here to, if a manager tells me they want to dismiss a person, I'm not there to do that, I'm sorry. Okay, it's not how it works. Hard on standards, soft on people. Colleagues, the disciplinary code and procedure. I just want to, sorry. My apologies for my back to this side. I can't move close enough. Can you hear me all? Everybody hear me? Yes. All right, you'll see this document was signed in 2013. It was signed by both unions, Nteo and Nahavu, which means since 2013, this document is applicable to each and every employee of this university. Okay. Whether you're a part-time person, even student assistants fall underneath these policies. The moment you do work and you get money, you're an employee of the university, and this code is applicable. These documents were distributed to you yesterday, so I'm not going to go through it word by word unless you want me to, but I would like to highlight the important details of this. Do you want me to go through it word by word, or are you okay? We're all professionals here. All right. Just very important, colleagues. You'll see there under paragraph 1, the employee's obligations. Now 1.1, to attend work punctually and be available for the hours of work contracted in order to perform the duties agreed upon. Working hours, 8 to 4. If you work 7:45 and you work till 4 o'clock, or you work from 8 to 8:15, you get every second afternoon off. I know people say it's very nice working on Shoshanguve and Garankuwa because there it's every Friday off. It's not supposed to be like that. Okay, so that is the rules of this institution. Yeah. Yes, what? Yeah?
I hear you are saying that people is nice to work in social media.
Well, I promise you, every presentation I've given some, and I can tell you, I love Shoshanguve. I'll move there tomorrow if I can. So, really? Okay, you see, that's good, but not all departments do that, sir. So not all do that, but it's very well that you are complying with the rules of the university, and we appreciate that because that's how it's supposed to do. At least in Heads, I can tell them it's not happening in Heads. I will do that, I promise you, in the future. Okay. 1.2, anything else? 1.2, to perform the agreed duties in a satisfactory manner. Colleagues, we all sign job profiles, did we not? If you didn't, please tell me. I'll very quickly have you sign a job profile. You know what is expected from you. Don't you want to wake up in the morning and say, I love going to work, I've got the job to do, and you feel, you feel worthy in your job. There's rules regarding what is expected of you. And this policy also says you must do the work that you are getting paid to do. 1.3, to obey lawful and reasonable instructions. Now this was debated on numerous occasions. Yes?
The presentation went on.
Okay, I don't know how to fix it, sorry. Is there anyone here that can? I'm law, not. Wait. I'm sorry, I'm not IT, but anybody can help me? Okay, great. Thank you. All right, so what is a lawful and reasonable instruction? Colleagues, that is for you in your department to determine. If it's related to your work, it's lawful. If it's against duty policies, it's unlawful. And no manager can take disciplinary action against you for not complying with an unlawful instruction. So that is something that you need to decide. I don't know what instructions would be lawful or not in your departments. You need to know that, but as a professional person, I think you would know when something is lawful or unlawful. Lawful for me is if it is in the policy. If it's against policies, colleagues, it's unlawful. We've got situations where very senior staff members, they instruct people to do something, and the more we tell them it's against policy, and then we just refuse. And I would like to see that manager try to take disciplinary action against you if it's an unlawful instruction. That is why we are in the mess where we are, because people don't comply with finance policies, people don't comply with HR policies. Colleagues, the policies are there for a reason. Okay. Any questions on that? Yes?
Let me just a question. Let's take me as an example. I've got a performance agreement with my line manager over there. So I understand when he gives me an instruction, I have to adhere to it. So we've got a performance agreement, so we get an external instruction from somebody higher up in the hierarchy for me to do something which makes it impossible for me to adhere to the performance agreement that I've got with my manager, for example. Who's entitled to give me lawful instruction? Just my line manager or everybody in the hierarchy?
Well, for me, I follow instructions that my line manager gives me. Unless she's not there, then I follow the next line manager. If things need to be done, we need to go through managers. Otherwise, how's the manager supposed to regulate and monitor what's going on in his departments? So for me, that's a very important thing, and it's good practice, colleagues. It's only good practice to go to the line managers and to have it from one, so everybody knows what's going on. So for me, but when it comes to lawful or unlawful, what I would recommend in a situation like that is to write to your line manager and say, listen, I got this instruction from, or request, I hate the word instruction, I got this request from this person, do you agree I should proceed? If you're at any stage uncomfortable, your line manager will then tell you, yes, proceed, or no, don't proceed.
So that means if, let's use today as an example, not in my performance agreement. So it means I'm not in my office doing something that I'm supposed to be doing in terms of the performance agreement. So that's not going to get done.
Well, you must make time. Now, I hear what you're saying, especially if you've got daily things to do. I understand that, but colleagues, also part of the job profiles is that you must attend seminars and things that is scheduled by the university, and if it's requested for you to attend to. But if things are not getting done, then you've got a reasonable reason for that, but you need to discuss that. People talk and talk about it, discuss it, and just on a way forward, if I don't know your environment specifically how it works, but for myself, I know for this week, I've got these cases to work through. Every day, this day, I need to do this, this, and this, and this. So if I'm in a seminar, from 9 to 1, I do it from 8 to, you try to manage it the time-wise, but I understand with you, it might be difficult to fit it into that time slot, but you need to communicate then that it's a good reason for being here. I mean, it's expected from you to be here. So they can't now go and say, listen, you didn't comply with your performance management system because the work wasn't done. But if the work was supposed, you got the instruction 2 weeks ago, you can't now say, okay, no, I couldn't do it because I was here, because that's unreasonable. You had 2 weeks to do it. But if someone gave you an instruction this morning and you're not available till 1 o'clock or whichever, then do it afterwards, But then you've got the reason to say, I couldn't attend to it now because I attended this situation. It's all about communication and what is reasonable and what's not.
But on that basis, we can actually get busy during the whole day. Just argument's sake, 40% of our working week we sit in meetings, which is not in our performance agreement at all. But then we have to make sure that we we reach our performance targets as well. So the only way to do that is to start working overtime, which will not compensate.
Yeah.
That gets a bit-
Yes, I understand that. What I would advise you to do is to have a relook your performance management agreement, to include these things that's in any case taking up 50% of your time. That's only fair, because currently you're doing work and you're not going to be monitored on that work. So relook that and discuss it with the line manager and come to an agreement going forward. And if they refuse to change the performance management agreement, then what does your line manager expect you to do? So then I would say, then tell him, listen, this is the situation. If it's not in here and I'm not going to be monitored on that, then please, I cannot assist with that because my own work's not getting done. Is that not fair? Sorry, yeah?
Now, when you've raised the issue of performance agreement, please elaborate on the status of their implementation.
I said the difficult questions for afterwards. Colleagues, the performance, even myself as I'm standing here, I signed my performance agreement. The policy on how to monitor that, the policy, I think it's called the Policy on Performance Management System, that policy is not yet approved. It's still with the bargaining forum, but there's a bit of problems in getting that policy approved. But colleagues, the fact of the matter is, if there's not a policy to guide it, doesn't say that it's not necessary for us to perform. Okay. Sorry? Sorry? Someone want to say something?
Is it lawful that,
What's lawful?
that we're doing something, but it's not there? You don't have a policy.
Okay. But the thing is, we've got the Labour Relations Act that still guides performance management. Okay. In terms of the Act, we talk about incapacity. Incapacity based on either ill health or incompatibility or poor work. So we don't need the policy because the Act is there.
But internally, what do we have?
Internally, you've got your performance management agreement, okay, and you've got your job profile. So if you do not comply with that, then the Act will follow. The fact that there's not a policy to guide it internally doesn't make the Act go away. All right, and the policy in any case would have incorporated the Act, because no policy can in any case go against the Act. So if a policy is against the Act, that policy is invalid. All right, so if you want me to go through the performance in terms of the Labour Relations Act, I'll do that as well for you today, just to explain to you how it works, what is the procedures to be followed. But colleagues, it doesn't say that because we don't have a policy now, nobody needs to do their work. You still got your performance agreement that you signed. If not, you got your job profile that you signed for, that's in your position. And if you don't have it, I'm going to urge you to contact organizational development. You can contact Rinki van Heerden or Bongani in Durban. They can forward you your job profile. Okay, is that clear? Okay. Colleagues, to act in good faith and not to act dishonestly in regards to the employer's interest. Very important. And even my friends that I made in the university will tell you. The first thing, one day I even sat in the CCMA, and I can call her by name, Isan, she's the secretary, she sat opposite the table at CCMA. I'm firstly an employee of the university, secondly I'll be your friend. We weren't friends before I started here. Doesn't mean that I'm not your friend, it's just I'm here to do my job. And I expect that from each and every person. You're firstly an employee of the university and secondly, friends. Okay, it's not that big, it's not that hard. Okay, and it doesn't mean that you can't have friends or you can't be nice to people, please, it's not what I'm saying. I'm just saying you have to act in the best interest of the employer at all times. At all times. To behave in an orderly manner. I'm not going to elaborate on that one. Colleagues, then you can just have a look at the paragraphs. Just the second paragraph there, you'll see of the first one, from the above, it follows that management has a right to expect a certain standard of work and conduct from an employee. Okay. Where an employee has acted in a manner prejudicial to these management rights, appropriate disciplinary measures must be applied. All I'm saying is we can't leave everybody, these rules are here for a reason. If we've got over 5,000 employees in the university. Can you imagine if we give a final warning, for example, to someone for sexual harassment? That means 5,000 other employees can commit sexual harassment once before being dismissed. That's what it means. They cannot be allowed. That's why we've got rules in this university. All right. the code provides the framework of the disciplinary action. You'll see when we get to the code, it's very clear. It says if you do this, this will happen to you. It's got columns. It says absent from work, first offense, second offense, third offense. Okay, so it shows you if you do this, these are the steps that will follow. And please, discipline is a progress. It's a progressive discipline. We can't just give you for being late once you be dismissed. It's not how it works. Okay, you must first start with counseling, then written warning, then final warning, and then could lead to your dismissal. You can't have 2 final warnings or 3 final warnings or 4 final warnings. First thing the CCMO will ask you is, how was this guy supposed to know that the final warning was the final warning? Okay, makes sense, no? All right. And you can't build one case on the other one to get rid of someone easier. It doesn't work like that. Sleeping on duty has got its own set of warnings. Being absent has got its own set of warnings. Not complying with the instructions has got its own set of warnings. Right. Policy statement.
That's interesting. So are you saying that if a guy commits a minor offense, this offense, there's a verbal warning. If he commits another offense, there's a verbal warning.
Yes.
So that it doesn't escalate to a...
No, unless it's same or similar. Okay. But each group has got its own set of warnings. Okay. Otherwise, we will have big problems here, because I heard in some of the other departments when I did the presentation, I came to sleeping on duty, everybody looked at the HOD. I'm like, uh-oh, okay. So, okay. All right, policy statement is the policy of the university to maintain discipline in a fair and consistent manner. All right, what happens in your department should happen in other departments. There's nothing that makes an employee more aggrieved than to find out that he's getting disciplined for something but other people get away with it. It's not fair. Okay. Then you can have a look. It is not possible to standardize the maintenance of discipline completely, but you'll see in this code, for example, rape. It's not in the code. But that's a criminal offense. So don't think because it's not in the code we won't fire you, dismiss you at the end of the day. Murder, it's not in the code. But I promise you, if you commit murder, you will be dismissed. Okay? So criminal activities, even though it's not in the code, we still all fall under the South African law, which says it's not allowed. All right. Principles and standards. You can see there that this code and procedure, it forms part of the university's conditions of employment. Hopefully they are doing it, but even when people are appointed, new appointed employees, and they have that introduction and that whole thing that HRD arranges for them, these things will also be explained to them. It's part of your conditions of service. That's why if we need to want to change this code, we can't just change it. It goes to the bargaining forum where the unions and everybody agree to it, and then once they agree, only then can we change these things. Okay, all conditions of service cannot one-sidedly be changed. It must go to the bargaining forum in duty's case and be bargained upon. Okay. The provisions of the code do not exclude the right or the duty of management where applicable to report a criminal offence. Criminal and labour are two different things. If you commit murder, you go to jail, but we still need to discipline you internally. Okay. Otherwise, when you come out of jail, you'll come back to TUT and say, where's my job? All right, so it's two separate processes, but they work parallel with each other. Disciplinary action is a line management responsibility and should be taken at the lowest possible level of supervision. One thing I ask is, if there's a problem in the department, please don't immediately go to your executive senior director, because we must get her probably to chair grievances, chair disciplinary hearings. Go to the next line manager, or in manager's case, come to us if you want to discipline someone. We'll work with it, and I'm not saying keep things away from senior management. I'm just saying we can notify them, listen, we've got this situation, but this situation is being dealt with now by ER. But if you tell her about it, you go to her and you talk about it, I can't use it to chair, and then we're outside of the policy. All right. So chairperson must always be objective, and they must have no knowledge of a case. And if you discuss that with other line managers or senior managers, we can't do that. And seriously, colleagues, you're not guilty until you're found guilty. Do to others what you want to be done to you. Don't go and discuss cases with everybody else. It's not fair, it's not nice, it's unprofessional. If there's a situation, come to us and we deal with it. But now I found departments, and I hear the line manager, that they came to ER, and then when ER started the process, oh no, we know about it, oh no, we know about it, oh no, you know, what's going to happen with this case? It's not professional. How would you like it if other people go and discuss your matters with other people? It's not nice. Okay, so please keep it internally, keep it quiet, come to us, let us deal with the matter. And because what happened in the past is a person will be found not guilty. And then he's got the stigma, no, but he did this and he was charged for this. It's not fair, colleagues. Okay, and you wouldn't like it if that happened to you. Right. I just want to check where I am now, sorry. Okay. This is from the, sorry. There you see, from the commitment that disciplinary matters should be dealt with at the lowest possible level, this deviation from the rules of natural justice is tolerated in order to ensure the maintenance of law and authority. Basically what this means is, as I indicated to you, a chairperson must be objective and he must have no knowledge of a case. But I would prefer a senior director in heads to chair matters because she understands your department than having the executive dean of humanities come to chair it. They have got no knowledge, they don't know how it works, they don't know your departments. So that's why we are saying please keep them out of it, because if they are informed about this process, then I'll have to get someone else. And it's prejudicial. Okay, it's always best like for employee relations. If I do something wrong, I would like my boss to chair it, my line manager to chair it, for example. Because she knows what I'm supposed to do, she knows what the job is about. She knows the department, she knows what, you know, who we meet, who we see, all those kind of things. We've got two unions in Tshwane University of Technology. We've got Nahavu and we've got Nteu. Both unions have got currently full-time shop stewards. Basically that means we've got a person specifically for Nahavu and a person specifically for Nteu to only deal with disciplinary action. They are trained to represent, they are trained with the labor law, they are trained employees to assist you in all matters. Each and every employee of this university, it's your constitutional right to be represented by the union. Okay. If you, Nahavu's full-time shop steward is Peter Nimangani. I'm not sure what his contact detail is, but you can find him on the system. Otherwise, you can phone the secretary, the personal assistant, it's Pupuru. He's on the system as well. You can contact him. If you're from Nteu, the full-time shop steward is Willem Kloppers. You can contact the officers, or the secretary is Tanya. Tanya, unfortunately, I could see her. Thanks. So please, you contact them. It's your right to be represented. I've got many cases where employees try to represent themselves. Really, it's not advisable. It's not, even myself, if I have to go to disciplinary, I'll get someone to represent me. Okay, so please just take note that you have got that right. You'll see the disciplinary code will not be used for the purpose of intimidation or victimization. If it comes to our attention that this is happening, colleagues, we will go to the line manager and we will expect that line manager to discipline that manager who's doing this. This code is for everyone, and it's your right, if you put in a grievance, it's your right to put in a grievance. And if you are being victimized after that, you tell us and we'll deal with that. Right. You'll see here the disciplinary code is also applicable to all employees, including post levels 1 to 4, to all employees of the university. It just says union leadership must be treated as per the Labour Relations Act. That just means if you're a shop steward, or well, what do you call a full-time representative, or a shop steward, as the Labour Relations Act calls it, there's other procedures that needs to follow. All right. So if you want me to go into that, I will. Are you okay? All right. There are no shop stewards here. The main objective of disciplinary action is to protect the interest of the university. As labour turnover has a detrimental effect on an institution's interest, disciplinary action should be of a rehabilitating nature. It doesn't mean if they start with action that you must be dismissed. Colleagues, that's not what this is about. This document is in place to correct action that's wrong. To inform you, listen colleague, what you did was wrong. Please do not do it again, because if you continue with this action, you could be dismissed because it's against the university rules. That is how you must see the code. It's something to help and to assist you to make sure that everybody is doing their job and what is expected of them. It's not to say when you see this, I heard some managers pull up the code, you see this thing. It's not that, okay? This code is in place also to protect you as well as the line managers. You'll see there, rehabilitation, educational action. You see this is the routine, informal action a supervisor takes during the course of his duties. A subordinate doing the wrong thing may be doing so in ignorance. But now after today, you can't say that you didn't know, because the attendance register will show that you were here and I informed you, okay? So this is part of that to make everybody aware of the university rules. But you'll see the corrective action. Corrective action is applied when educational action is not indicated or failed to bring about the desired performance. That's why we start with counselling. To say, listen, you were late now for this past week. What happened? Now I overslept every morning. Okay, but now, that's not a valid reason. So please don't do it again, because if you continue to oversleep in the morning, then we'll have to follow and give you a written warning afterwards. So that is to help you and to counsel you, to say what you are doing is wrong. Please stop doing that. But if you continue, don't think we're going to leave it. We have to take this matter further. Right, warnings are given for first offences of minor nature. Final warnings are given for serious offences and in repeated cases of the same or similar offences. And employee found guilty of an offence while on a final warning for the same or similar offence may be liable for dismissal. As I said, you can't have a final warning on a final warning. Very important, just there you'll see counselling sessions, they didn't put a timeline on counselling. But you'll see verbal warnings is valid for after, will be valid after the employee has shown some positive behaviour over a reasonable time or period. For verbal warnings, it's minor offences, colleagues. Here I talk about being late for work. Okay. Then you'll see after a month, this person hasn't been late again. Now, of course, you're not going to, after a month, now start issuing with a written warning. Because a reasonable time to be not be late for 1 month is, in this university, a very, very good thing. Okay. So you'll see also there, written warnings lapse after 3 months and final warnings after 6 months. Prevention. When educational and corrective action is not indicated or proved to be ineffective, punishment must be considered. In the case of a dismissible offence and where the accused employee's presence at work may prejudice in investigation, interference, or intimidate witnesses, he or she may be suspended pending a disciplinary hearing. Suspension pending an inquiry or pending an investigation, that is with pay and with all your benefits. But colleagues, if you are suspended, don't expect the university to pay for your overseas conference in Las Vegas. It's not going to happen. Okay? So, but you still get paid, you still have your leave. What we find is people being on suspension in the university for a year, and then they never take their leave and they want the leave to be paid out. It's not going to happen. If you want leave, you take it, you apply for it. You're still an employee of this university. Right. You'll see there such suspensions will always be on full pay, and the accused employee must, at the time of the suspension, be informed when and where to report back for further instructions within a period not exceeding 60 days. I must admit, it doesn't happen a lot, but most suspensions is more than 60 days, but at least the Employee Relations Department or the line manager should give you reasons for the reasons of the delay. Most of the times when we do not comply with the 60 days, the investigation is not finalized yet. So those are things, but you must be notified of the reasons before 60 days. Yeah?
Disciplinary code applicable to
Yes. And we've got reasons for those suspension delays. And they were informed of that. All right. Any other questions? But this whole code is applicable to everybody. Yes?
Not only, we go through the 4 disciplinary objectives, which refers to actions. So the whole disciplinary code is referred to actions. But I would like to...
Sorry, where are you? On page?
Just number 4.
Oh, number 4, yes, yeah. Yes?
You refer to the whole intended purpose is to correct actions.
Yes.
But I would rather use the word behavior. Because
Yes.
behavior is different than an action. And I know from my previous knowledge about disciplinary codes, the intended purpose of a disciplinary action is actually to change behavior.
No, well, thank you for that. I will make a note of
And I
it.
think that behavioral changes is much more comprehensive and inclusive than just an action.
Yeah.
And
Yeah.
I think that's very important.
But discipline is about the action, remember. We can't discipline you for a behavior, but we can discipline you for an action that you committed, or what you did. So that is the reason, rationale behind it.
Unacceptable behavior that needs to be disciplined.
Addressed. No, that's correct. And I think I skipped it, but it does mention in the beginning also that it's to correct behavior. I see it talks about the actions, but it's because we discipline the action, not the behavior. But thank you, it's noted. Well, I will note that for the bargaining forum proposals. Thank you. Anything else? Okay. Colleagues, prevention, I've discussed that with you. Level of authority, definition of a supervisor or manager in terms of this code is any designated person who has direct line authority over the accused employee. So any one of your line managers can institute these actions. Delegated disciplinary authority, you'll see there the level and the extent that person is authorized to take disciplinary action. Supervisors, HODs and deputies directors are only allowed to issue warnings. Only directors, deans or executive deans or EDs, executive directors, my apologies, and DVCs are entitled to issue final warnings, transfers or dismissals. A final warning and dismissal is very serious. So we can't have any line function doing that. It must only be senior managers who's allowed to do that. That's why usually for final warnings we will schedule a disciplinary hearing and we will have a committee to chair that who's authorized to make a finding. Composition of the committee, when we schedule the disciplinary hearing, what will happen, colleagues, is if you commit assault, your line manager will contact employee relations. Employee relations will not draft the charges. Okay, we will assist. We do training specifically for line managers where we teach them how to do this. But I'm not going to draft the charge, but I will assist. So what we expect the line manager to do is do a proper investigation, and based on his investigation, first thing he will do is he'll take the code, check in the code, okay, is it against one of against one of the things in the code? If it's there, then you'll start with that process and indicate to us an email, we found this is our draft, what we would like to charge this person. Then we will help to say, okay, yes, but let's put it like this, we'll start with this, we'll put it in the correct format, we'll put it on the document. You know, that's where we will assist. But we do not do investigations. And how can I draft charges if I did not do the investigation? All right. So what will happen is the line manager will contact us, they'll write us the email, and we will schedule the hearing. We will firstly make sure who's the line manager, we will schedule that person as a chair, we'll get an assessor in, we'll contact, we'll get the whole committee in place, we'll get the date, time and place, we'll get the notice of the hearing, we'll record everything on the notice, we'll contact the employee to say, please come and collect the document. Here's your notice to attend the hearing. These are the charges against you. Do you understand them? It's very important, colleagues, that you know your rights. You must understand the charges. You must have sufficient time to prepare. You've got the right to be represented. If you want your rep there, then you say, please give me 10 minutes. I'm quickly going to phone my representative to come and join us. Unfortunately for us, when we phone you, we don't know if you're represented or who is your representative of choice. So we will contact you, and then you must indicate to us If you are represented, we will ask, of course, but then who that person is so that we can make sure they're also there. So after you've received the notice, you'll have to attend the hearing as scheduled. And at the hearing, when you walk in there, you'll see, okay, there's a chairperson, there's an assessor. The whole purpose there is a chairperson. He must make the decision at the end of the day. But he does have an assessor there to assist. Okay, employee relations is also present. Our role at the disciplinary hearing, it's only to advise on procedures. We advise the committee, we advise the employee, we advise the initiator. Employee relations is not supposed to be calling the witnesses, make sure the witnesses are here. The only thing we will do is if you struggle to get hold of your witnesses, you will inform us, we will assist to get them there. But I'm not there to say, call this person, call that person. It's not our process, we are there to assist on procedure. That's why I always say for managers, please schedule training sessions so that you can do what to do in case of a disciplinary action. Also present, everybody's got the right to an interpreter. So if you want an interpreter, what ER does, we will phone people from Applied Languages, see if they can come and assist us with the hearing. And also the representative, your representative of choice will be there, and the initiator himself will be there. Witnesses will not sit in during the process, they will only come in to testify and then leave. Okay, any questions? You'll see their roles and, any questions? You'll see there's roles and functions of parties at the disciplinary hearing. The chairperson, a member of management, preferably within the same department or faculty's line function, who did not take part in the investigation. You can't be the initiator and the judge. It's impossible. Okay. There is no grudge against the accused, nor has any vested interest in the outcome of the case. Chairs the proceedings and actively seeks to establish all the facts by asking questions to clarify and test all evidence, and makes the decisions as to verdict and where applicable the sanction. So should this be your disciplinary hearing and there's someone appointed to chair, but then it's your right to object to that chairperson, and what you'll do is at the hearing your representative will say, I've got a point in limine, or he'll start and say, I've just got an issue with the chair because of the following reasons. Then you must cite them. So it's your right to have a fair and objective chairperson. The initiator usually is the accused's immediate supervisor who is accountable for the employee's performance and conduct. As I said, it's part of the manager's job profile to manage his employees. It's not nice, discipline's not nice, but it's their job. So should you ever be in a disciplinary inquiry, don't feel it's personal, the line manager's being personal. It's basically employee relations is forcing that line manager to be the initiator in terms of our policy. All right, so it's what's expected from them. Employees representative, I've indicated already the unions. Accused is a staff member who has allegedly committed an offence. ER department acts as an advisor to the employee's representative as well as the committee. What's not in here is advisor to the initiator as well. We advise all parties, yes?
Perhaps we could just do that. With the initiator, it says to try and prove the accused's guilt on balance of probabilities.
Oh, okay, thank you.
I just want to distinguish that from...
Yes, thanks. When you go, I don't know if you watched the Oscar trial, very big news a few years back, but there they had to prove beyond a reasonable doubt. There must be no doubt in the judge's mind that this person is guilty. Do you know how difficult that is to prove? It's very difficult. With labor, the only thing the initiator needs to prove is that on a balance of probabilities, this employee is guilty. The chairperson will sit there and he needs to weigh the two. He will say, okay, who is the most likeliest to be telling the truth? That's what labor is about. Who's the most likeliest? It's not beyond reasonable doubt. 50% plus 1. That is what the chairperson decides upon. Now, usually if it's a 50% plus 1 case, the chairperson will still go for the employee because, chairperson, they always try to be fair. But when we go to the CCMA, the only thing the university has to prove is that plus 1. Okay, but that is what's a balance of probability. Is that clear? Thank you. Anything else? All right, then we have a look at the assessor. Assessors who will be appointed by the ER division are members who join a disciplinary hearing in complex or high-level cases. Such members are objective outsiders, but still TUT employees, but not people from the same department. So to make sure that we get that objectivity in there. Interpreters, where a staff member is not familiar with the language used, he or she has the right to call for an interpreter. And as I indicated, employee relations will arrange for that person to be here. Decision of the committee. The disciplinary committee should draw up a complete report of the facts and submit the decision of the committee to the representing union and accused within 14 days after the finalization of the case. Always ask for a report in writing. It's your right. It's your right to have that report. Should you be found guilty, it's your right to have reasons for that. Okay, rights of the accused employee. Prior to disciplinary hearing, the accused employee has the right to be informed in writing the nature of the alleged offence, to be supplied with copies of all documentation at least 10 working days prior to the hearing. But colleagues, what counts for you counts for the initiator. If you have documents that you would like to use at the hearing, you must also submit those documents to the initiator at least 10 days before the hearing. Otherwise, they're just going to ask for postponement and then this matter is not being heard. Okay, it's fair, both parties. To select a bona fide employee as an employee representative to assist with your case and to time your scheduling of the hearing. The right to be notified within 7 work days after the incident has been reported of the intention to take disciplinary action and the nature of the offence. You won't believe me, I've got managers coming to see me saying, yeah, they've got a case. This person in 2012 didn't mark his scripts on time. Then I tell that manager, really? That's terrible. But this year, how did it go this year? No, well, I said, oh, the corrective action worked. Okay, colleagues, really, it's not reasonable. Do to others what you want to be done to yourself. Do you want your line manager to come 3 years afterwards and say, listen, there's this case against you? It's not fair. It's not fair. I know what happens usually when we've got audits. They come and they audit a period of time. But then from the date that the university receives the audit report, within 7 days you must be made aware of that. Okay. Yeah, sorry, who? Sorry, yeah.
What happens then if that time frame is not adhered to? So a dismissible offence. I come to you as my line manager, I complain, and you take 10 days to inform the person of the complaint. Does that complaint then just lapse or what happens?
Well, the thing is, the line manager must have reasons for that, and if he doesn't have reasons, he will be taken to task. But it doesn't make the fact that you committed a dismissible offence, all of a sudden now you're not going to be taken to a hearing. It's regarding the procedure. When you have a look at a dismissal at the end of the day, you've got procedure to prove and you've got substantive fairness to prove, the reason for the dismissal to prove. Now, on the procedure aspect, that might be a flaw somewhere, but it depends on the merits of the case if that flaw is so huge that the case can fall flat at the end of the day.
It's not automatically procedurally unfair.
No, because there must be good reasons. And if you go to CCMA, for example, for a case and there's a procedural flaw or unfairness, the CCMA will very unlikely order reinstatement. They will most probably only order compensation, what they see fit. All right, so but with substantive fairness, if the reason for the dismissal is unfair, then they will order the reinstatement for the person to come back. Okay, is that everybody understands? Then the right to be disciplined as soon as possible, but no later than 6 weeks after the date of the offence, when the employer became aware of the incident, unless the investigations are complex and take much longer. But again, the employee must be kept up to date and he must be notified of the reasons of the delay. Hearsay evidence may not be used unless the rules of evidence dictate otherwise. Why this is in here, there's a situation, for example, where students don't want to come and testify. for fear of victimization or whichever. But then there must be a proper application to the chairperson, which you must consider. And then what we'll do is most probably say, have 2 rooms, the student and the chair will sit on this room, and people will go vice versa and ask the questions. But remember, you always have your right to cross-examine any witnesses. That's why they say hearsay evidence. It's a very problematic evidence to use. Right. The outcome of the disciplinary hearing must be announced within 14 days of the hearing being completed. During the course of the hearing, you've got the following rights: to state your case, to give your side of what happened, to cross-examine any witnesses that the initiator may call, and also to call your own witnesses, and to utilize the services of an interpreter, and to be informed of the verdict of the chairperson. If found guilty, the offender and the employee representative have the following rights: to be informed of the justification of the verdict, the reasons behind that, to submit mitigating circumstances to be taken into consideration. Mitigating circumstances is what you would like the chairperson to keep in mind to make the sanction less harsh. Don't come there and again start with your whole story of what happened. These are things like you're the sole breadwinner, you've got 2 kids, you're a single parent, you've got things that you would like the chairperson to keep in mind. You've worked for the university for 20 years and you've never had a warning against you. Those are things in mitigating. Aggravating, the initiator will give aggravating circumstances. What happens sometimes is the initiator will also give mitigating. It doesn't work like that. If you don't have aggravating, then you say so. But aggravating will be things like what they want the chairperson to keep in mind to make the sanction more harsh. Like you've got already on a final written warning. What you did is you stole money from the university. The trust relationship is broken. You know, those are things that of aggravation to make the sanction more harsh. Obligations of the employee. During the notice period pending a disciplinary hearing, the accused employee has the responsibility of arranging the attendance of his or her representative and of his or her witnesses. The same goes for the initiator. He must call his own witnesses to the hearing. You'll see there, employees should note that a hearing will continue even if you are not there. If you do not show up for the hearing and the employee relations can prove that you received the notice, you were aware of the date and time, and you didn't call in to say you're sick, and you don't produce a medical certificate, you just stay away, know that the hearing will continue in your absence. So please, if this ever happens, which I believe will not, please come and give your side of what happened. Okay, I'm not going to, these things I've already discussed. Oh, where am I now? Sorry. Hey. Sorry, just a second. Witnesses. There is no management authority to subpoena witnesses. Witnesses, if called, shall voluntarily appear for that part of the proceedings relevant to their testimony. Statement, if requested, can only be voluntarily obtained. And evidence and names of witnesses pertaining to the hearing must be made available to both the accused and the initiator at least 5 days before the hearing. But nobody can force you to come and testify. But colleagues, if you saw someone assaulting someone else, why would you not come and help the university to see justice? So my question would be, is why is a staff member refusing to come and testify? Because the only thing the committee can ask you is to come and tell us what you saw, what the truth is. So why would anybody refuse, even if it's for the initiator or for the employees? Why would you refuse to come and assist? Because a witness must only tell the truth. And colleagues, if it's found afterwards that a witness lied during a disciplinary hearing, that's under making a false statement in our disciplinary code, and that is a dismissible offense. Okay. Legal action. You see there, you can go through those things, but what will happen is management will try to resolve all issues through our disciplinary code. And after that, should you be dismissed, you can go to external dispute resolutions. Incidents may occur which give rise to civil or criminal proceedings. As I indicated, if you are charged internally for disciplinary hearing, it does not mean that we cannot institute criminal or civil action against you. We've had cases, especially in finance, where people stole hundreds of rand. So don't think we're just going to dismiss you and say bye-bye. Okay. So the university has got the right to also go to and lodge a complaint and open a case. You can go through the rest of the things. Just important, appeal hearings. Everybody's got the right to appeal the outcome of the hearing. All the grounds for appeal you see there, you must indicate on your document where you appeal, what is the reason for the appeal. If the verdict is not supported by the evidence, penalty is too severe, now you're being dismissed, but the code says you must only be issued with a final warning. Procedural irregularities as indicated. Okay, new evidence, biased chairperson and inconsistent application of procedures. In heads I was dismissed, but in humanities the person only received a final written warning. So those are all grounds for appeal. Disciplinary procedure, I'm not going to go through all that. I did indicate a lot of these while I went through the document.
One thing, when an aggrieved initially raises an issue with the line manager, is there a prescribed format that notification needs to take, or can it be a verbal or preferably? Okay,
so just say again, if an employee raises a what?
So I've been bullied, so I go to my line manager.
Okay, I hear you. Okay.
Do I make just a verbal declaration or a prescribed form that we take?
Okay, what I'm going to do, if you don't mind, that's part of the grievance, step 1 of the grievance procedure. So when we get there, but just in short, that can be verbal. I always prefer to have it in writing so that you can prove, have your trial of where you went with this process. But I'll discuss it further in detail when we get to step 1 of the grievance procedure. Okay. Okay, then I just want to, you'll see here the code. I'm going to go to the code. Colleagues, this code, employee relations, is trying to have this code revised. You'll see when we get to some of the things indicated in here that it's not possible. Yeah.
I'm sorry, Ma'am, I want to ask, previously you said if somebody was arrested, say for murder, like the university
Yes.
would also dismiss them.
Yes.
Is that only subject to that criminal offense being done on campus grounds or to a university employee?
Yeah. Now, everything that's relevant to the university. For example, if you'll see also when we get to the code, it's mentioned off-duty misconduct. But if you commit a murder in Johannesburg, it's got no relation to TUT, they're not going to dismiss you for the murder. But because you're arrested, you cannot comply with your duties as an employee to come to work, so you will be dismissed because you cannot come and perform your duties, and based on that. But for the murder itself, the university cannot dismiss you for the murder.
Okay, so because they can't perform the duties for a certain period of time?
Yes,
Okay,
yes.
so say, let's say I took 1 month's worth of leave, and then that thing happened, and I was only going to be away from work for 3 weeks, meaning I've got a week of
Yeah.
Is that going to be treated differently?
Well, you will be charged for the week that you weren't here, but if you leave whether approved and you followed the policies, but thank goodness if you commit murder, it won't be a month, it will be at least a few years. But in cases if it wasn't murder, but other things that you were arrested for, the university can't be held accountable if it's not on university premises or related to the university. But for that week that you weren't here, that's unauthorized absence. And for that week, we will charge you.
A final question. So if somebody was on sabbatical for however long, and then they were going to be arrested for a year and they had 3 months left of sabbatical or however, well, that not affect anything because they were not going to be at work for that 3 months in any case.
Yeah, but the sabbatical policy on sabbatical leave has got your own rules and regulations to comply with. So if you take sabbatical leave, you must, for example, come back and work that time back to the university. Secondly, you must get your degree. If you don't do that, you must pay back the money. And, so all of these, it depends on how that affects the university at the end of the day. And in terms of those policies, what you contravene in those policies. Okay, but the university cannot dismiss you for something that you did in your own personal time. Nobody even knows that you're from TUT. TUT is not related in any way to that matter. That's got nothing to do with the university. A husband kicking his wife at home. It's got nothing to do with the university, unfortunately. But it's got nothing to do with the university. We cannot dismiss that husband for assault. Even though I would like to do that. Okay, does that answer your question?
Yes, thank you.
Okay. Anything else? Yeah.
I'm going to use a silly example
Yes.
just to
Yeah.
illustrate the point. Say, for example, I don't like going to the AL.
Yes.
Right? So I phone Prabhat, so every ALP and TLL, I have a tummy bug or a runny nose or whatever. And she's identified this pattern and has asked for a medical certificate. But now it's less than 3 days.
Yeah.
And I can say I didn't go to the doctor because I took Imodium. In that case, firstly, how does she respond to my leave submitted on the system? And secondly, is there any action for the failure to produce a medical certificate in such a case?
Okay, firstly, the medical certificate, the policy says that you must produce a medical certificate if you're absent for 2 days or more, and also if you're absent for more than twice in a period of 8 weeks. So irrespective, if in a period of 8 weeks, that's 2 months, if you are absent more than once, you need to produce the medical certificate in any case. Secondly, if you see there's a pattern, and you see it's every time when a departmental meeting is scheduled, ALP is scheduled, then you have got the right as a line manager to request that person to go to bring a medical certificate because you see a pattern. And you, as a line manager, is not saying that person is committing a misconduct, but you are concerned. And you want to check if they are all right, and you want to make sure that they see appropriate doctor for that. Okay.
But
So,
if they don't.
Sorry?
If they don't produce a medical certificate, then what is that?
You'll see here, you'll see when we go down here, failure to produce a medical certificate number 5. A medical certificate must be produced for all absence or more than 2 days. An employee is expected to obtain such medical certificate within the stipulated 2 days. You can have a look at that. It will fall under that. You start with written warning, then final warning, then dismissal. Okay, it's quite serious. So you as a line manager has got the right to ask for that, all right? And then you, if they don't submit that, then we must start. But I wouldn't start with written warning. I would call that person in and say, listen, I've seen this is what's happening every time with ALP. Can you tell me what is happening? What is your side? What happens? Soft on people, hard on standards. You don't just go and jump and say, yes, your written warning, you weren't at ALP, or you didn't bring your medical certificate. But say, I asked you to do it. Why did you not go to the doctor? I don't have money. Oh, but there's clinics. Oh, I didn't think about that. Okay, but next time I ask you for that, think about the clinic. Soft on people, hard on standard. Yeah, ma'am.
What happens then if you don't go to your normal doctor? You consult a traditional healer.
Traditional healers are recognized, but they must be registered. All right. So if you've got a registered traditional healer, and then that is accepted by the university as a medical certificate. But their registration number must be on there, and they contact, those things must be a proper. Okay. No. What is it? Colleagues? Yeah. Anything else? No?
Just because I'm weird about details. It says on here more than 2 days, but you said 2 days or more, which is it?
Yeah, well, more than 2 days, 2 days, so more, it's...
That's different.
2 days, but okay, let me check here, hold on 1 second. Then I can quote you, and my apologies, then if not, so hold on 1 second. I said the difficult questions afterwards, not now during the sitting. All right. Colleagues, just give me a second, then I can give you the correct one, and I can read it from here, so then there's no sick leave. At least employer, wait 1 second. Medical. More than 2 days or more than on 2 occasions. Okay, so sorry, it's more than 2 days. So for 2 days you can be absent, but from the 3rd day, not. And it says here, an employer is not required to pay an employee in terms of this section, the sick leave section, this is section 23 of the Basic Conditions Act, if the employee has been absent from work for more than 2 consecutive days or on more than 2 occasions during an 8-week period. Okay, so it's more than 2 days, but colleagues, then the university still pays you, but it's not, they don't have to pay you even that for them. Okay, thank you. Anything else? Can I move on before you ask any other questions? I'm going to go through this code. You'll see there's the offence. It starts at 1. Then you'll see first offence, second offence, third offence, and then the fourth offence. The first, under A, it's absenteeism. You'll see number 1, absent for 1 or 2 days, 1 to 2 days. First offence is counselling. Then the second offence is a written warning, then a final written warning, and then that could lead to dismissal. You can see here it's not written warning, second written warning, third written warning, fourth written warning. It's 1 written warning, but it's only valid for 3 months, the written warning. Right. I'm not going to go through each and every one and say first, second, third offence. I'll mention the first offence, and then you'll see, you can just check the rest. Is that okay with everyone? Absent for 3 to 5 days. First offence is a written warning. Abscondment or desertion is dismissal. What's the difference between absent from work and abscondment or desertion? Absent from work is you've got the intention to come back to work. Desertion is you don't have the intention to come back to work. Okay. So how do we know that? We start with desertion proceedings. We give you a date to come to the hearing. If you show up for the hearing, it's not desertion, it's absent because you had the intention to come back. If you do not show up for the hearing, it's desertion, and we'll stop your salary from there. Okay? Or we'll remove you from this, indicate that you deserted on the system. Failure to notify the supervisor of his or her absence from work. Counselling is the first offence, and then written warning. What is a reasonable time? I know the policy is silent of when you should notify your line manager that you are absent or sick. I want to know from you, when do you think is reasonable? Anyone?
As soon as you become aware of the reason.
Okay. Before 8? It's reasonable before 8, no? Some departments say no, before 9. All right, but you're supposed to be at 8. So you should have known by 8. Huh? So colleagues, please, can we have an agreement of everybody here that for this department of heads, a reasonable time to notify your line manager that you're going to be absent or sick is before 8 o'clock. Okay, everybody happy with that? So colleague, if you do not do that, then counselling, yes?
Not being funny now. What if
Yeah. Sorry?
What if you're in a car?
Yeah, you've got reasons. There's merits to every case. If you're in a car accident and you can't talk, that's understandable, and that will be dealt with in that, when that comes to light. So we've got a situation when one of the people, he was sick, but for 3 days we couldn't get a hold of him. For 3 days we could not get a hold of him for being sick, not in hospital. So we're talking about cases that's fair and reasonable. But if you're on a car accident on your way to work, it's not reasonable to expect that person while he's being driven with ER 24 down to hospital to quickly phone the boss. It's not reasonable. Okay, so each case has got its own merits. That's why I say hard on standards, soft on people. The line manager won't just come and when you come back and say, here's your counselling, here's your warning. She must ask what happened. And if the reason is valid and reasonable, really, we're not going to go to the disciplinary action. Okay. Okay, 5 I've dealt with. 6. Keep pushing the wrong, sorry. Abuse of sick leave, colleagues. It's now too far. Okay, so abuse of sick leave, very important. You guys think it's not happening, it is happening. We've got situations where people, I think in the last month, they were only at work once or twice a week. And then if you're so sick that you can't come to work, really, by the end of month 3, I would like a report from the doctor saying what's wrong with you, because then there's something seriously wrong. Do you realize, colleagues, in the private sector, employees, and in terms of the Basic Conditions Act, employees only have 30 days sick leave in 3 years. We've got 90. I don't know who gave the university that 90, because really. But we've got 90 days. Private sector 30. 30. So If abuse of sick leave, the lineman, that's why I say you check the sick notes. What we found also is people committing fraud on sick notes. But that's not here, that will go to fraud. Okay. Abuse of sick leave, just the definition there. If an employee is absent from duty under false pretenses, for example, to conduct private business. Now I'm so sick I can't come into work, but people see me shopping at Truworths, buying my new boots. Okay. Hi? No. Valid question. But you don't get nice boots, that's prescription. Okay. All right. Tampering with medical certificate or submitting a fake medical certificate. Dismissal on a first offense. Dismissal. Anything that's fraudulent or where dishonesty is involved, colleagues, it goes into the heart of the employer-employee relationship and it will be dismissal on a first offense. Standard control, we'll look at poor timekeeping, first offense counseling, loafing or idleness, first offense counseling, poor work performance is a first offense written warning. But colleagues, there's a difference between poor performance as a misconduct and poor performance as an incapacity. Incapacity is you cannot do the work. It's not where it's a misconduct, it's an attitude problem. I do not want to do the work. That's the difference. First offense is a written warning. Sleeping on duty, please don't look at your line managers. It's a first offense is a written warning. Obviously, the sleeping on duty will differ, for example, for security, where their main duty is to stay awake and protect. For security, it will be different. Okay. Anything else? Holding or attending meetings on company premises and in work time without management's permission. First offense is a written warning. Conflict of interest, final written warning. But colleagues, it depends on the merits of the case. Conflict of interest, since the new act came in for higher education, so I think it was 2014, the new act says that you're not allowed to have a conflict, you're not allowed to do private business with universities and things, since that act came in, obviously, if it's things pertaining to that, it's dismissible offense. Because the law supersedes any policy. Okay. That's why we want to review this policy, because the people who, I was on maternity leave, I was not involved, but the people who drafted this policy, they thought evasion of postage was very serious. So evasion of postage is a dismissible offense, people, so please don't take anybody else's mail. Okay. So it's dismissible. Yeah. Derivative misconduct. Employees failing to report misconduct by another employee. Final written warning. You work in a lab. There's 3 people working in the lab. Those 3 people is in the lab from 8 to 10 only, sorry. Now 2 laptops are missing. Between those 3 people, it could only have been one of them. What this also means is we can charge all 3. So if you don't want to come forward and tell us who it is, because you should have been aware, you should know who it is, then we will charge you as well under this one. Colleagues, let me say, this is the situation. I'm coming into the lab for 2 hours with 2 colleagues. Everybody sits there. It's the 3 of us works in the lab. Now when I and my 2 colleagues walk out, 2 laptops go out as well. And I do not report it, but you should have known or seen that somebody took those laptops. That, it's only in those circumstances where this will apply. I'm not talking about other people's also got access and people going in and out. I'm talking about 3 people, for example, only having access for this period of time to this place, and it could only have happened in that time. Then the university can expect you as an employee to come forward and tell us what happened. But if you do not want to do that, it could only happen one of you 3, or will be charged under this. Yeah.
But what if you are scared of being victimized or bullied? 1. Secondly, if you weren't present when these things took place.
Yeah. But okay, if you weren't present, then obviously you weren't one of the 3 in the venue.
But if the premise was that you sit there and you should have known.
Yeah.
But I mean, you understand what I'm trying to say here? So you cannot just assume that I was present at a particular moment when things happen.
Yeah, but what we're saying...
I have to now
Yeah.
show that I was
Yes. You must show or indicate from your side, but I wasn't present in this time slot. But these are only extreme circumstances, stances, colleagues. We have never used this one before. This is really if it can be shown that you three are were in this venue. It can be shown we've got cameras here, and the cameras indicate you three were the only ones in this venue the whole time.
And the cameras will show the two to the
Yeah, well, but yeah. But the fact of the matter is, we always say in Afrikaans, die deler is so goed soos die steler. The one who's assisting, and it's just as good as the one who took it. If you walk out with other people and you see them taking stuff that they're not supposed to, and you do not report that, you are also going to be charged. And if you're fearing victimization, I think I missed that question. Then we've got our hotline that I heard it's working. What you do is there's a hotline. I don't have the number, but if you want it, I'll get it for you. You phone the number, it goes through to KPMG, and you notify them. Or you come to employee relations, you indicate to us, and we will protect the name of the person. But it's expected of you, of the university, to always act in the best interest of the university. And if you see something that's not right continuing, it's your responsibility to make the university aware of that. Anything else? Yeah.
When I look at that, it seems to conflict with another statement that you mentioned earlier, that they can't force me to testify. Because that forces you to testify.
Yeah, but remember, testifying is at a hearing and it's a whole process there, but this is making the university aware that something is happening. It's, for example, now you work in finance, you know for a fact that your line manager is, instead of paying students back their money, he's paying himself back the money, and you keep quiet. You cannot do that. It's not the same when you witness and testify. That's when you come to the hearing, you go on record. But mentioning that I see two people fighting, am I just supposed to walk? I didn't see them. No. If someone assaults me, then I would really expect someone to stand up for me and say, stop doing that. Think of yourself. If you are the one walking there and someone just assaults you, do you want people to walk like that? Ach nee man, Really, I'm very disappointed if that is how it works here. Okay.
Naomi,
yes.
One more question. Tell me something. Why is this being, and this is, please don't get me wrong, it's not, I've known of people in other departments, not in it, that's, why is this taken up so seriously? But when it comes to loafing and things, number 2 on your list, I mean, it's almost impossible for this university to fire someone because it's a written warning, it's counseling, and everything needs to happen within 1 to 6 months. Why is it not taken up so seriously? Things like that.
Yes, you know what my answer to that is, and I'm sorry if I'm offending someone, that's bad management. That's bad management. No, wait. Because what that written warning means, and that counseling session means, it says, if this happens once, you must do this. Second time it happens, you must get a written warning. Third time you're loafing, you must get the final warning. Now some managers come to me and say, hey, I want to have this person dismissed. And I say, okay, what happened? No, he's not working. I say, okay, now please show me what you did from your side as a manager in this matter. No, it's not happening for 3 years. Okay, but where's the warnings? No, I don't have warnings, but where's the counseling? No, I don't. Then I'm saying, okay, but really? Then we start from nothing, and we start with the counseling session first.
But I'm really talking about people in other sections, out of this, that I know for a fact, but they're managers of the DVC. So then, it's not happening. They're staying here, they're laughing, they're not doing their tasks, they're not coming in, they're not at our work. And it's just continuing because they managers of the DVC.
Yeah, what I've done is, and I know Prof. Makola was at the ALP, and I hope that he gave feedback, but he's very strict as far as I've seen him. And he indicated and he supported me when I said, if you as a manager is not doing your job, I'm not going to come to you as a manager, I'll go to your line director. And if that line director is protecting you, I will go to the next line manager. And the problem is, we at Employee Relations, we are not aware of what's going on. We know, but I can't do anything if I don't get something from people, complaints, grievances, something in writing. We don't get that. Then we hear, now you complain about other departments. And all I'm going to then say, please, you need to write to us so that we can sort it out. But currently we do not have that. Then people say, Employee Relations, you've got 200 cases. And I say, okay, please show them to me because we don't get it. And when you talk to me outside of this room and tell me things is what's going on, the first thing I'll tell you is please put it to me in writing. And I can tell you now, of all the people in this university that I've trained yet and have taught me stuff, I've received maybe one complaint afterwards in writing. One. Then I want to ask you, is it really that serious, or did you really have your facts straight? Because then we're asking, put it in writing to us so that we can look into it. I said this is university, and that's why I'm doing this roadshow to go into departments. I've met with a lot of other departments as well to say it's time that we take back our university. It's time that we stand together to address things that's not right. And I hear your concern because we did hear about stuff, but the thing is we can't do anything about it if we don't receive it. And I can promise you, when we did receive a complaint, we will push through with that thing, even if it goes to the Vice Chancellor. Okay, yeah?
So if I want to complain to some kind of a hotline or anonymously,
yeah.
When am I protected if it happens to come out that I was the one that...
No, you're a whistleblower. You will be protected in terms of the Act.
Where can you blow whistles? What kind of structures?
No, it's a valid question. It's a valid question. What I would recommend is, it depends on what the matter is about. So if you've got something that you feel is very serious, then I will urge you either to come and talk to Employee Relations, but otherwise to contact the hotline number to KPMG. Okay, because they don't even say your name.
So you can't like have a Facebook post done and then expect it to be protected?
No, it's not. No, going to the media, that's not protected. You can't be protected there. I'm sorry. Okay, you must follow procedures, either by notifying your line manager, secondly putting in a grievance, or thirdly phoning the hotline, or you can even write to the Vice Chancellor himself if you want to, or to the DVC. I mean, certain things are very serious, and the university, it seems as if nothing's happening about them, but do the right people know? So depending on what information you've got, it depends on that information, on where I would advise you where to take it. But the safe route always is the hotline number, if you're scared of victimization afterwards. Okay, let's move on. Off-duty misconduct, this is where we come in, all right. This is any act or omissions outside work hours that bring the university's name into disrepute or affect the employment relations or have the potential to do so. We are going on a team building session, we are on the bus towards the venue, and there I don't like my supervisor, so I kick him while he walks past me. That is related to TUT. Even though it's not on our premises, even if it's not on our working time, but if it's a TUT function, after hours, whichever, but it can be related to the university, this will come into effect.
Naomi?
Yeah.
Social media. The type of posts that we do there, we have to be, our social media platforms are our own space, right? And after hours, posting something negative about the university or commenting how badly we feel about the strikes or something along those lines.
There's a case that came out last week where exactly something similar happened, where the employee, after hours on Facebook, he wrote how bad his managers and what. He was dismissed, and the court said, good for you, company. So basically what I'm telling you is, if you go on social media and you say bad things about the university, don't expect the university just to sit back and say, oh, shame, it was after hours, now I see it's on Facebook. So please, if you want to write bad stuff, make sure there's no TUT employees on that web. Okay. So no, it is dismissible. It depends on what you write, but you're not allowed to do that. It goes into the heart of the university, and it's against the whole our image. I can think about a lot of things that we can charge a person like that for.
This is a very grey area because, say for example, one of the news sites, News 24, does a very bad article on TUT, and that's a repost. Would something like that even be considered bringing the university into disrepute?
Well, the thing is that you reposted it, but that's difficult. I'm sorry, I'll have to come back to you on that one, because the way that I'm seeing it is, the fact that you reposted it, yes, but how do you as a person know that it's not true? Because the news already, it's like the newspaper, they bring, when Molefe was here, they wrote all the stuff about, and we coming in here and we pass the paper around, all of us wants to read what the newspaper says. That's a similar thing. How do we know what the newspaper said is correct? But I see it in a similar light. But I'll have to get back to you on that one, because it's a difficult question. No, but it's an important one.
Very, very important one, because I know a number of us are agents on many sites.
Yeah.
And we post a lot of university-related stuff, and sometimes it's good and sometimes it's bad. So
I'll just have to check, and we'll have to check our policy on communications. I'll have to check what that says, because I even know, for example, our own corporate affairs, they will also, I'm also linked to one of their profiles, and they will also forward it. So I'll have to check the policies. And I'll have to get back to you on that one. So sorry, I can't answer that question currently. Okay. Anything else? Yeah.
Sorry, I think that's something that we kind of need to pay attention. I'm thinking a lot of people actually, when they post Twitter accounts, go to great pains to actually state overtly that this is my own private opinion, I'm not representing my own company, and they post something which is offensive. And what then happens is Twitter picks this up, and somebody finds out that I work at TUT, and they say, this guy who said this works at TUT. Now I'm bringing the university into disrepute. But what I said is had nothing to do with the university at all. I mean, we know about the racist tweets.
Yeah, but that's what I wanted to mention as well.
That is exactly what happens is Twitter picks it up. And it had nothing to do kind of with your employment. But during that post going viral, people become aware that you work at that university. And now it brings so some people will say that it brings the university to disrepute. Yeah, this case was a little bit.
Well, everything that you do. Let me start over. The university. Let me use the racist example of what came out. We've got policies in the university that does not allow racism anywhere. We do not allow discrimination anywhere. So the fact of the matter that you mention it to yourself, that says something to the university of you as a person. And we cannot say that we agree with that. I'm sorry, we will never do that. And that's why the university even will take this stance to say, even that you do it in your personal name, but the moment that the university, even if Twitter doesn't pick it up, but some of your colleagues picks it up, all right, let's say that happens, and it's not even a major thing that like in the news last week. The university will still charge you as a person for making those remarks. Okay, anything else? You mustn't frown. Okay, negligence, colleagues. First, negligence. First offense is a written warning, then you get gross negligence. Negligence of such a magnitude that will be viewed in a serious light, that's a final written warning. Examples, you have a look at negligent loss, when employee through carelessness or negligence causes university property to be lost, negligent damage, negligent misuse of university assets, negligent or improper treatment of confidential and sensitive information. We had a situation in one of the faculties where the people, they've got laptops, but they don't put them in with the security things, and when they leave the offices open, and what happened was somebody came in, took the laptop and left. That's gross negligence, because you should have foreseen it as an employee. That's why we give you the security. That's why we give you a key to your office. That's why you're the only one who has the keys to your office. So you must be, take care of the university property. Okay. You can have a look at the specific examples. Yeah. 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 Sorry. Yeah.
Just hypothetically, if you've done whatever with a student or potential student, whatever the case is, you've informed them they are not going to receive certain information. Okay? They've signed and they understand. You've informed them that information will be sent to somebody else, and that's marked confidential. Now that somebody else gives that information to that individual. Where does that fall under?
Because there's policies that guides this. Are you talking about exam things? Are you talking about... No, okay, it's fine. If you sign as a person that you will treat this thing as confidential, that means you cannot discuss that with anyone except the person that told that to you. Unless the policy provides that you get this information, then you take it to that person. And then you must make sure that that person also signs the confidentiality clause.
So you actually have to have a clause.
What we always do, even in the interviews, when you go into an interview, everybody signs that clause.
Okay, so if I'm going to hand a report over to you that is confidential,
yes,
it's not sufficient to just mark it as confidential. You have to actually sign.
No, it's fine, but you must make sure that that person didn't give that confidential report to 4 other people. But if that report is only, you need to investigate these things, and then you must find out who leaked the information. But if a report is confidential, if someone gives me a report and it says confidential, I may not discuss that with anybody except the person giving it to me, unless that person tells me, you can discuss it with these people. That is what confidential means.
Does that equally apply if you send it via email?
Yes, well, the same rules apply. The same rules apply. But remember, with IT, it's very easy for other people to get that information. But the rules apply everywhere the same. But to prove it at the end of the day might be a bit more trickier. Okay, but the rules are the same. Okay, you also had a question?
The other side of it, you are sitting in your office and one of the lights fall on top of your head and you get injured. And you have requested the university on a number of occasions to repair the light. This happened. What then? Because that's the other side. There's procedure that needs to be followed. Machine matters. The hush package. But that's another side.
Okay, let me give you my example. My car was stolen from my parking lot outside. It was November a year back. I parked outside there, and they've got the board there, say you're parking at own risk. What. So it's very nice. But when I came, security phones me, somebody drove with my car through the booms, out, gone. Okay, I acknowledge the seat that now. I acknowledge the fact that it says parking at own risk, but after that I notified the university. Firstly, I wanted some answers on my questions. Secondly, I wanted to know how are they going to fix the security issue. And I said, even though that I'm aware of the fact that I'm parking there at own risk, that risk was I was never informed about that risk, but now I'm informed and I want to know how the university is responding. Till today they haven't responded. Okay? So if my car gets stolen again, don't think I'm going to sit and pay for that damage myself. I'm going to institute civil action against the university. So the same with the injury on duty. If you are injured at work, you've got your injury on duty process to follow. But if you've numerous times, remember we're going to come to the safety also in the disciplinary code. If you've numerous times made management aware of the fact that there's a safety issue in your department, then the university will charge the person who's responsible for that. Okay, and for you as a person personal employee of the university. You've got certain rights that you can attend to, but injury on duty covers at least all your medical, things of that nature. Okay, but it's important that you know your risk and that you make the people aware of the risk. If they're not aware of the risk, what do you want the university to do? Yeah.
I honestly don't get this, but what does it mean you park at your own risk when you're actually expected to be here?
Please ask that question to logistical services. It's not the ER. I'm not the ER.
It's like if you're employed here.
Please ask that question. Please ask that question to the relevant departments. Can we move on? Okay. Financial misconduct, colleagues. You commit financial misconduct if you willfully or negligently fail to exercise powers and duties that are assigned to you. First offence is a fine or written warning. Offences against human dignity, practical jokes and horseplay, first offence is a written warning. So please don't make jokes with each other. Some of us are more serious than others. Abuse or insulting language, first offence is a fine or written warning. Colleagues, I'm here to tell you today, here it says racial harassment, first offence is a fine or written warning. I'm here to tell you today, even though the code says fine or written warning, we are looking to change that, and it's very serious, and it will not, depending on the merits of the case, it will most likely lead to your dismissal. Okay. Same with sexual harassment. You'll see the fine or written warning. I'm here to tell you, last year, the cases, people were dismissed. How can you expect sexual harassment, and especially when students are involved, how do you expect the university only to give you a final written warning? I'm here to tell you, I'm hoping everybody signs a attendance register, because we've got 5,000 employees. Imagine all 5,000 employees can sexually harass a student once. It's not on. Okay, yeah?
So it's just
okay, you can just... Okay. Violent conduct, final written warning again. Violent conduct, if it's against the criminal act, it will be a dismissible offence. Assault, yes.
Let's take the example of sexual harassment.
Yes.
If you reported such a case and it was dragged out, nothing happened, whatever, and it happens again. I mean, to come back to what you said of, the situation of your car. You reported the situation and people were protected. So
unacceptable.
Should it happen again, what can one do?
What you need to do is you need to go to the next line manager and explain and prove all the previous assaults. Then you go to the next line manager.
It was
really?
To the top.
No, I'm sorry, I don't have an answer then for you. That is, it's terrible. It's terrible. Sexual harassment, colleagues, you need to understand, it's very serious with the university. We've even got a whole policy on sexual harassment. Sexual harassment, it's difficult and sensitive as well. We've got processes that we've put in place so far, how to deal with sexual harassment. If a student complains about a sexual harassment from a lecturer or a staff member, that student will report it to whoever, okay, and to a TUT employee most probably, or otherwise they will report it to employee relations. But usually what happens with students, they know judiciary services, so they will go directly to judiciary services and they will forward the case to us. We will not immediately go and start disciplining staff members. First thing we do is we get, I think it's you guys, if I'm not mistaken, that we ask to sit with the student and to check and just do a formal checking for us what exactly happened. If it's a staff member that's being sexually harassed, that Dr. Legetu from Health and Wellness, she will first meet with that staff member, and then on a recommendation from her, we will then take over the matter from employee relations and continue the case or not. Unfortunately, most cases of sexual harassment, the people don't want to come forward. And the other half of sexual harassment cases, they only come forward 2 years afterwards. But procedure-wise, if a student complains, isn't it the student from heads, people from heads that is it you? Yeah. So the students. So what we ask is that from your side, you must notify employee relations if it's students. But most of our cases we get from Edwin Manyaka from Judiciary, and otherwise if it's a staff member from Dr. Lekgetu, or alternatively if the staff is prepared, they come to us directly. Okay, but because it's such a sensitive night, and believe me, guys can also be sexually harassed, right? Not only women. Okay. Anything else? Sorry about you. You have to give me details of the case so then I can follow up for you.
Because I'm really grieved by how it was handled.
Yeah. So maybe afterwards you can just give me please the details, because we okay, then we'll look into that. Okay. All right. Assault, attempted assault. You see there also final written warning. Now, of course, we can't allow 5,000 staff to slap one person at the university once. It's not going to happen. Okay. Yeah. Sorry. Yes.
Yeah. Sorry. The question I wanted to ask is, some of these offences happen somewhere behind closed doors where nobody else sees it, so it's like an offender and a victim kind of thing. And in terms of gathering the kind of information that's usable in being used to dismiss the perpetrator, how do you get the evidence together?
Well, the thing is, it's very difficult, but I can promise you, when you sit in that hearing and the two parties testify, that's why cross-examination and testifying is so important. Because I can promise you, in that hearing, you will know who's telling the truth and who's not. We've had cases in faculties where one student will complain and write us a statement, and based on that statement, when you sit in the hearing, you know who's telling the truth, and the lecturer was dismissed. So that's why cross-examination is important, because if you do that, then you can bring everything to light. So for sexual harassment, there's not evidence. What evidence are you going to get? You're not going to get evidence, for example, but you get people to testify, and even if it's one person, then you test it at the hearing, and the hearing will make the decision.
Okay, so you don't necessarily have to bring evidence when you lay a complaint.
In most cases, there won't be evidence, but a lot of them, what will happen is there will be messages, text messages, or there will be emails. Those things, of course, that will assist. But if there's nothing, it's not to say that we're not going to look into the matter, because even your testimony is enough. Okay. Anything else? Okay, colleagues, let's go. Yeah, anybody else? Discrimination, dismissible offence. Abusive language or signs on clothing is a final written warning. You'll see here intimidation and or incitement. First offence is a final written warning. Sabotage, final written warning. You see, I don't agree with any of these, but it's the policy at the moment. Possession of firearms or other dangerous weapons on company premises, final written warning. Do you agree with that? No. Would you like to know that the people around you is carrying their guns? What this says is everybody can do it once. So we don't agree with that. Okay. Gambling, final written warning. Again here, we are disputing this as well, so I want you to note it. Reporting for duty under influence of intoxicating liquor or drugs. First offence is a written warning. Consumption of intoxicating liquor or drugs while on duty, written warning. Illegal possession of liquor or drugs while on duty, final written warning. Listen to this one, you'll be shocked. Selling or distributing liquor or drugs while on duty, it's a final written warning. Colleagues, I can promise you, if you do that currently and you're being caught and you're going to be taken to a disciplinary hearing, you won't get a final written warning. You will be dismissed. Okay, yes.
If a manager becomes aware of someone who's using drugs and the behavior must now change, all those type of things, what is the role or the responsibility of the employer with regards to
yes.
the employee?
Yeah.
Do you say written warning, but isn't there other processes that should be in place?
Yes. Hard on standards, soft on people. You're not just going to call in the person and say, yes, your written warning. You're going to call him in and say, listen, Mr. X, it's now been a week, and every day when you come to work, I can see that you're under the influence. What is going on? Do you have a problem? yes, I do have a problem. Okay, let us contact Dr. Legetu from Health and Wellness, and we will schedule meetings with psychologists or whichever for you, or book you into places to help you get better. No, I don't have a problem. Okay, but that's not acceptable for the university. So unfortunately, I have to give you a written warning to make sure that you do not continue this action. Do you see the difference?
But we know that denial is the first step of the edit.
Well, we can't do anything. If he denies it, then we follow the misconduct route. Then the next time he comes to work again, trust me, by the time it comes to the hearing, they'll very quickly say, no, I've got a problem. Okay. So we can only go on what they say. If they say they don't have a problem, we follow this route of misconduct. If they do have a problem, we phone Health and Wellness to assist the person as much as possible. Okay. Yes?
I want to ask, that selling or distributing of liquor, not that I'm going to do that.
He's very quick to add that.
Like, I think it's the second or third one you said that if the university takes you on, you're actually going to be dismissed and you're not going to get a final award.
Yeah.
Does it mean that document will not apply?
Well, the thing is, the document applies, but based on the merits of a case, the chairperson will still take into consideration a lot of things. That's why your mitigation and aggravating circumstances at the hearing makes a difference. Because a chairperson can find you guilty on sexual harassment, but during the hearing in mitigating it can be, but it wasn't harassment, it was harassment, but you didn't know, it was a staff member and they never told you not to continue with it. So those can be mitigating to change the sanction at the end of the day. Or aggravating can be, it didn't stop with sexual harassment, he actually raped a student or a lecturer. Now really that will be aggravating to go for dismissal.
So
Okay.
are there policies that individually add those clauses concerning any of those? Because I'm specifically referring to that one.
Yeah.
I can understand the other one, sexual harassment, rape,
Yeah.
all that. But specifically that one, if somebody was dismissed immediately and they took you to the CCMA and they said, well, I went to a workshop and they said they're first going to give me a final written ruling, but that never happened.
Okay, luckily I'm the only one in ER so far doing the workshops, and I'm telling everybody at the workshop that it's a dismissible offence, so I'll show the attendance register there. But if you didn't go to a workshop and you just have the document and your managers didn't, and you only saw it and it says final written warning, that's fine, you can argue that, but what the university is going to argue is the fact that you're selling it and we work with students. And now what if you're selling those stuff to students? So the CCMA will not. This is a guideline, you must understand that. It starts at the top, it says this document is a guideline for the university to use in cases. But every case will be dealt with on its own merits, depending on what happened. Now someone lodges a complaint of sexual harassment because when I walked past this guy, he said, oh, you've got nice boots. The university is not going to dismiss him for that. But a warning, don't tell people they've got nice boots on. Okay, for example. But it varies. So every case on its own merits and depending on the severity, depending on that. Okay. Anything else? Yeah.
I don't know if they did this specifically or if it just happened this way. Under reporting under the influence and consumption, it says very specifically capable of working properly and being able to do the work with actual consumption while on duty. So hypothetically, if someone is doing drugs, they show up to work having taken drugs, which they did off duty, but they are capable of doing their work. Does the university have no recourse in that?
Well, it depends. If the university is aware of it, then obviously this guy's not doing everything right.
But if his work is of
well, how are we in any case supposed to know? But if the moment someone takes drugs is very serious, because the people, they get addicted and then you sit with a major problem. Then you can't dismiss people in terms of the code if they're addicted to taking drugs. So what we've realized over the time is people who start doing it at work, they start making mistakes. And then you address the mistakes until they come to you and say, listen, I've got a drug problem or whichever. Unless you see them sniffing the stuffy there and you see him smoking lacquer and you smell it and you see the eyes are red and people can't walk properly. You must see the physical signs for the university to be able to address that in terms of the code. Otherwise, you will address the work, or you address, you know, those things. Unless they tell you they've got a problem, then we follow the other route. Okay? But even for liquor consumption, you can't, unless you see them doing that, or you can smell it on them, or check the eyes. There's a whole checklist that managers can do. Unless it's one of those things, you have to address the problem, then the work. But if you can't smell them, use eyes or not, how do you know it's liquor or drugs? Okay, yes?
Students who are involved in prostitution outside the campus, what
Unfortunately, we work with only staff-related matters, but please address that question to Judiciary Services. You can speak to Edwin Manyaka. They've got a policy specifically on misconduct for students that they work with. Okay. All student misconducts they deal with, staff-related misconduct is employee relations. Okay. But doesn't mean that the students has got their own code of conduct and that they have to adhere to. And unfortunately, I'm not familiar with that. Okay. Anything else? Okay. Very, very serious. You see number 5, driving or operating university vehicles under the influence of alcohol or drugs. Final written warning. Compliance-related offences, insubordination or insolence. Insubordination refers to unwillingness to submit to authority, directly challenging the authority of a supervisor. So written warning on the first offence. Insolence is towards a supervisor is shown by disrespect, rudeness, use of offensive language or manner, in general being disrespectful. First offence is also a written warning. But now I also tell the managers, why do you leave someone to do this continuously? We must all respect each other. So if there's no respect, address it there and then. Refusing to carry out a reasonable and lawful instruction. This amounts to gross insubordination. This is when an employee directly or deliberately confronts the supervisor by, for example, refusing verbally or making no effort to carry out the work when instructed to do so. This, for example, is when you're sitting in a departmental meeting and they say, okay, you please, you're responsible for this, you're responsible for this, and I say, I will not do that. Who are you to tell me that I must do that? It's not, I will not do that. You see, that's gross insubordination. First offence, final written warning. Failing to carry out an instruction, first offence is a written warning. It's failure to adhere to or execute work according to a lawful and reasonable instruction. Okay, yeah?
How do you know where that line is? Because that's a tricky thing. You know, I'm employed as to do certain things. Now I get an instruction to open a meeting with prayer. So it's an instruction, but it's not inside of my...
Okay. Okay, then it's the way that you do it. Are you being disrespectful when you refuse, or are you not being disrespectful and explaining your situation? It's about the communication. If you're going to say, who are you? Because really we've had situations where the employee will say, who the hell are you to tell me to do this and this and this? And then there's a situation, say, apology ma'am, I cannot do that, it's against my religion to do that, and sorry, I'm not comfortable. Do you see the difference? It's attitude. The difference is in attitude. Okay. Yeah. Sorry, just quickly there. Sorry, yeah.
What you've been asked to do falls clearly outside the scope of your job.
But that's why we say, is it reasonable and lawful? Remember when we started, even I thought you were going to debate with me that, but so it's depending on you and your environment if it's lawful or reasonable. It's not reasonable for my line manager to tell me to go and cut the grass, really. It's not reasonable for any of us to do that. But it's reasonable for technical services to tell them, listen, go and do that. It's part of their job. It's reasonable when we have a meeting in our department, or I schedule the meeting, and everybody's there. It's reasonable for my line manager, because it's my meeting, I called it, to ask me, listen, please, quickly, let's set up cups, let's quickly check if there's coffee, what. It's not reasonable for her to ask me, however, to go and wash it if we've got a cleaning lady to assist with that.
But what if there's ambiguity?
Sorry?
What if there's ambiguity? So for example, right, it says in your job profile, part of your job is doing X. But your line manager is now asking you to do something which could be interpreted as that,
Okay.
but could also fall outside the scope of it. Who decides that?
Like it's between you and your line manager, but I mean, if it could be interpreted to be in your job, then I would see that as a reasonable instruction. My job profile, for example, doesn't say that I must come and do a presentation to heads. It doesn't say that I must train managers, but I do it. It can be expected of me to do that. It doesn't say that I must have meetings with line managers or with staff members. It just says I must assist with grievances, disciplinary codes. So you will know best if that can be expected from you or not. I'm doing this, I'm doing presentations, I'm going to meetings, I'm driving around from one campus to another, but it's not in my job profile. But it's in my line of work.
But why is it not?
Yeah, good question. They must upgrade my post level immediately.
So you are saying these things are not put in the job profile so that job.
No, that's not at all what I'm saying. Okay, please. I'll get in trouble, yeah. No, that's not at all what I'm saying. What happens is if you have look at your job profile, it says, and there's always this one sentence at the bottom that says, or anything else that can reasonably be expected from you. So go and check, it's there. Okay, so all these other nice stuff that we actually don't want to do, it's there.
Yeah, but you see this anything else?
No, I know, but that's why if it comes to a stage where really it's a lot, then you need to look at those things. And I hope that is what they are trying to do with this 21st century process, is to go and look at these specifics. Because another example is secretaries. Secretaries have got a standard job profile. But our secretary, for example, at employee relations, she receives faxes from CCMA, she replies to CCMA, she drafts objection notices, she arranges the bargaining forum stuff, for example. It's not on a job profile. But it can be expected from her as a secretary in ER to do that. So I'm hoping they will correct these things. But please, it's not there that the university can pay you less. It is there because we are looking at we need to fix these things, but it's a process that needs to go forward. Okay. Anything else? You wanted to say something?
Yes, I just want to know what if the manager is disrespectful and rude?
Then you've got the grievance procedure. Okay. Perfect. Okay. Non-compliance with prescribed procedures, rules and regulations of the university. First offence is written warning. Divulging confidential information to unauthorized people. Final written warning. Violating copyright or license rights for computers, programs or any other copyright. Final written warning. Unauthorized internet access and access to and downloading out of bounds web pages or material from the internet. Final written warning. Dishonesty. You can see here everything dishonesty is dismissal. Okay, yeah.
I just want to ask, I've seen this through the years, but many times when you walk into an office, not in the heads environment, but other environments.
Never in heads, no.
I've seen that people are playing cards on the one saw that one staff member was looking at the number.
That's unacceptable.
I just want to mention this one, perhaps if you can deal with it, because these are things that take place.
Okay, but then if you see something like that, you must make the line manager aware of it. What else must I say? It's the truth. If it's not in heads and it's in other departments, then they must be made aware, the managers. And if the managers are not doing nothing about that, what did I say? Well, I indicated in the beginning of the sitting, then you come to ER and we will go to the next line manager. Especially pornographic material and those things. I'm sorry, it's not tolerated at this university. And playing cards, we go back to that. Idleness and loafing goes back to that. Okay. Yeah.
Specific question around the outside work policy. So the last time I read case law about that, basically the rule was as long as you don't compete directly with your employees or conflict of interest, and you don't come to work tired, then basically outside of working hours you can do what you want. And then you ask for permission to do outside work. Because that's what policy requires, and your manager then unreasonably refuses to grant you the permission to do your work outside, but he just doesn't like it, basically says no, for example. what do you do there? Can you carry on with that outside work and take your chances, or what do you do?
No, the case law you're referring to, just check them, because I'm almost sure those companies do not have policies in place for outside work. We do have a policy that says you must apply for it. If the line manager refuses it, you put in a grievance and you sort it out in terms of our policies there. Okay, but you cannot, without permission, just continue with your outside work, because should the university become aware of that, they will charge you for doing outside work without having permission. But you've got your rights in terms of the grievance procedures to do that, especially if they are unreasonable, because that goes close to victimization. Okay.
That's exactly it. Now I don't want to lodge a grievance because the guy is doing it to me is my line manager.
Yeah, well, colleagues, you want the processes to help you, but how must the processes help you if you are scared? I understand the problem, and I understand the problem that victimization and those things are very serious, and bullying is very serious in TUT. But we have to, you've got your rights. So if you do not want to make use of that rights, then how must employee relations help you? So I'm urging people who are scared of victimization to please come forward, because there's only one way of dealing with that, is to come into the open so that we can address the point.
Just a comment, and it's not a question. You know, we come from a dispensation where we were bullied, and this type of practices was acceptable.
Yeah, I know.
So it's, for me, it's all about the paradigm shift. Secondly, these labor laws and policies and guidelines was used as a tool to scare people.
I know.
And today, it's actually an eye-opener that the paradigm has shifted in the sense that we are, as employees, is just as important as those who manage us.
Yes, no, it's absolutely true.
And if we can just get over that hurdle, I think immediately people see the benefit.
Yes.
Of course, and I can say this. This morning coming here, few of us thought, why are we having this? Something happening?
Oh, shame.
And I like the statement when Shafika opened, she said, never would she like to have a process where people will be engaged in a disciplinary. And that in itself put, I think, everyone at ease.
Yeah, shame.
Because it is a concern.
Yes. Now, I understand, and I know where you're coming from with your comments also of bullying and victimization, but I think in employee relations, and myself standing here, Dorothy Koza is our director, and as I'm standing here, I can tell you with all honesty, it's the best, she hates it when I call her bossy, but it's the best boss that I've ever had. And if there's one person who will fight for what's right in this university, it's her. So if you are scared of victimization, we've got the director who will assist and help as far as she can every step of the way. We've got the new executive director who is now recently appointed. She started on the 1st of May from Walter Sisulu University. What I've seen from her is it's a person who you can walk a path with. So, but it's now less than a month, but she seems as if she's going to, work with the policies. But I can testify myself here that at least if you're scared of victimization, Dorothy Koza will treat your matter sensitively and to the best that she can, and she will fight for that matter up until the highest place. Okay. All right. Anything else? Okay. Giving false evidence, making a false statement, dismissal, bribery, corruption, dismissal, fraud, dismissal. Sorry. Forgery, misappropriation, you'll see all those are dismissal. Unauthorized possession of or removal of company property, dismissal. If you remove your laptop without the removal permit and they catch you at the gate, unauthorized removal. Okay. Theft, dismissal. Then we have a look at other misconduct. Unauthorized opening, tampering, destruction of mail. It's very serious. It's a final written warning. Intentionally hindering or delaying of mail, it's final written warning. Prejudicial conduct is any conduct that damages, harms, or disturbs or has the potential to damage or disturb the maintenance of good order and the smooth running of the university. Sorry, it's a final written warning. Any act or omission which seriously impairs the relationship between the university and the employees or the students is a dismissal. Incompatibility. This is the inability on the part of the employee to work in harmony either within the university culture or of the business or with fellow employees. It's a written warning. Okay, yeah.
Just number 6 and 7, unauthorized removal of company property.
Yes.
Why are they treated the same? How do we know that this is unauthorized removal and how do we know that this is theft now? I have a laptop at the gate and I'm about to pass out and it was only like something that I forgot. And now you are dismissing me and somebody comes with a laptop stolen and then why are they treated the same?
Okay, but why do you per accident remove your laptop in your car? You just managed to per accident put the laptop in the car and drive through the gate. How does that happen?
First week of university for the year, many managers are still on leave and unable to sign the removal permit.
Okay.
So and you didn't get it at the end of the year. So
Okay, but the policy says you can't remove it without the permit. So then you wait for the manager to come back to sign it before you remove it. Okay. But then you need your permit. Then you can work very like a long hours from home. Sorry, just 1 second.
Just last week I was training maintenance outside campus.
Yes.
I needed a data project. My manager signed, but the people at the assets were not the whole 3 days because they were outside.
Okay.
My manager signed. What must I do?
Okay, but tell me now, when did you become aware of this?
Long time.
Oh, okay. And why now, the day before of the training, you want him to sign?
3 days.
Okay.
I've been trying to get them. I did not get them.
Okay, but what I'm saying is you know about this long time ago. But okay, valid question. Okay, valid question. And I feel, I'm not sure exactly of the wording of the removal, of the policy on removal. But I think if your manager, that's the most important part. If your manager is aware of it and the manager agrees, I cannot see, because the manager must charge you at the end of the day, and I cannot see any manager charging you at the end of the day if he agreed for you to remove that. Okay, in short, does that answer? Okay, Ulrika?
I think there's confusion because if I have a removal permit and it's in my office and I forgot it there, but I have permission that's there.
No, that's fine.
I have the guy and I tell them, I'm sorry.
No, that's fine. That's fine,
But if
yes.
you don't have a permit.
Yes. No, thank you for clarifying that.
If you have a permit.
No, and you just forgot. No, I agree. But as long as you've got the permit to remove it.
Yeah.
Okay. Anything else? Yes, ma'am.
I just want to find out, I had a permit, I took it home, but on my way home I decided to buy bread. And by Spar, they steal my laptop while I was inside. Am I responsible?
Okay, let me tell you what the policy says, and I only know this because I've got cases in next week that I need to deal with. You'll see on that document, when you sign it, the permit document, it says the moment that you remove it from TUT property, it's your responsibility. So what I've done with my laptop is I've put it on our insurance at home. Okay? So if it's stolen off campus, then it's not, because I need to replace it then or fix it. Okay? Colleagues, go and read. Hey? No, go and read your removal permit. Go and read it. It says the university insurance will cover that laptop on campus. But the moment you remove it, it becomes your responsibility.
And why the removal of permit?
Well, it just says that you may remove it. Okay, that you're not stealing the laptop, that you're going to work at home. Yes, ma'am.
Does it not then affect what does it mean that if I'm expected to also work from home, respond to things from home, then if it's my responsibility to pay insurance for them?
And I'm not saying you have to. I said I did it because I'm not prepared to pay for a laptop afterwards. I did it. But ma'am, then it's your decision to say that you're not prepared to work from home anymore. So then you must check that. You must check your job profile and see if the university must expect you to work from home. But if you are not prepared for that risk, then you must speak to your line manager about that. But the permit, and if you have queries about the policy, you can contact the asset department. That's how we understand it when you look at that permit that you signed. It says when you remove it, it's your responsibility. Okay, so for me, I also work from home, so to cover myself, I put it on my insurance. Man, it's not much, it's $20 a month. So really. I'll give you the details afterwards. Yes.
With practice, actually, we have to take our laptops home. So it was supported given that we must be prepared during strikes to work at home. So I'm not going to put my insurance up and up it because of strikes at UT. That's not fair. That was not my decision.
Okay, but that is something for you and your line manager to sort out. But if there's protest action here, and they, in any case, can't just tell you to take your laptop home because there's procedures to follow. You must complete the work permit before the time. Okay.
No, that's in place. The work permit is
Okay, so you've got those things in place.
But I mean, it's not my decision. I would love the laptop just to stay where it is on campus.
That is where the risk comes involved. So if you're not prepared for that risk, it's something for you and your manager to decide on. Okay, unfortunately, I cannot answer. I don't have the policy on assets in front of me. But for me, you must know what is fair. For me, I work a lot from my laptop. I travel with it everywhere, and I'm useless without my laptop. So for me, I did that because I don't want to pay that at the end of the day. Yeah.
We work on different campuses.
Yes.
So I come from social media, something individual. How can I be responsible for that again? Even if I have everything, irrespective of what, I think this should really be revisited.
Okay.
Because we have a unique situation.
Yes. I'm also like that. I'm also working on Shosha and Polokwane and Mbombela. So I know. So yes, it's a good idea to revisit that policy. Unfortunately, it's not an HR policy. So if you want it to be revisited, please contact the appropriate people for that, which is assets, if I'm not mistaken. Eh? I think it's the asset department or someone in finance. Okay. But I'm only here to tell you what I found for my matter next week. Okay. Unfortunately, don't shoot the messenger. Yes.
The case that what happened is laptop was stolen from my house. But police came in, they saw that there was evidence of breaking. We submitted the evidence and the insurance actually paid out.
Yeah, from TUT.
So there's no problem.
From TUT paid out.
Yeah.
TUT's insurance.
Yeah.
Huh? Okay, I'm not aware of that. Because we tried that 2 months ago with another matter and they refused.
Maybe it was kind of, because it happened a while ago.
I don't know.
But I think what happened in that situation is that the insurance company said, if theft can be proven, then they'll pay it. But if theft can't be proven, then they won't pay out. And then it becomes...
Okay, what I will do, I'll contact on your behalf, I'll contact Rudy Stander, who works specifically with the insurance. And I'll ask him this question, not on our policy based on, but what on the insurance of the university says on this. And then I will notify Prof. Ansu, and then she can communicate that to you. So before all of you refuse to go and do work at home, let me just check what our insurance says. Okay, so let me give you then an informed decision on the insurance side, but I can tell you now the policy and the permit, it says something else. But if the insurances themselves are willing to pay out on certain aspects, then by all means I will give you that information in writing so that you can use it against me at a later stage. Okay? Yes?
Just to help quickly, the TUT insurance actually requires that you need to prove that the notebook was on a secure cable, that steel cable. That is either if you're at a conference, in your hotel room, or at home.
Okay.
Otherwise, they won't do it.
Okay, but what I will do is I'll get specifics for you. And even if you need to, I'll get a quote from the document that they use. I'll get specifics, and then you can make an informed decision whether you're going to remove the university property or not. Okay. Can we move on, colleagues? What time is it? Hey, you see, you are all keeping me up with stories. I'm just kidding. Okay. All right. Occupational safety. Failure to wear personal protection equipment where required is a written warning. The top one, non-compliance with prescribed working procedures is a written warning. Reckless and negligent driving is a final written warning. Possessing of explosive substances is a final written warning. You see, now, possessing of explosive substance is a final written warning, which means 5,000 employees can have an explosive thing on them. It's not on, eh? Okay, so depending on the merits of this case, it most probably will rather lead to your dismissal if found that you've got a bomb on you. Okay. Misuse of first aid contents is a written warning, and negligent use of drugs or medication is a written warning. Occupational health, intentionally negligently creating a potentially unsafe situation with reference to viruses, it's either dismissal or a final written warning. Misuse of laser equipment, final written warning. Colleagues, if I'm not mistaken, that's it for the code. You'll see here attached is the... I must get someone else to come and work this thing for me. Okay, you'll see here attached also to the document is the code of good practice. This was taken exactly as it is from the Labour Relations Act. Not going to go through that. You can go through it by yourself. It just says what is the code of good practice in terms of the act. But what we've done is we've incorporated that in any case into our code. All right. Any questions on the disciplinary procedure and code? Thank goodness. Can we move to... Hi? All right. I now want to have a look at the grievance policy. Colleagues, the grievance policy is specifically put in place for any and all employees of this university. If you are aggrieved about any right that you've got, oh, God. Okay, can you see that? Is it a bit unclear? So a grievance is there for rights. You've got the right not to be sexually harassed. You've got the right not to be victimized. You've got the right not to be discriminated against. You've got the right to 35 days leave, 45 if you are very lucky and in the academic. You've got the right to 90 days leave because that's part of your conditions of service. You've got the right to fair labour practice. Those are all rights given to you in terms of the law, the acts and the policies of the university. You do not have the right to 50 days leave. That is an interest the people can have. And if you've got that interest, then you bargaining forum. You have got the right to 35 or 45 days leave, but not to 50. So if you want 50, that must go to the bargaining forum for your unions to bargain on. Okay. You don't have the right for, what other examples do you have? But basically, so that's if there's an interest, it goes to the bargaining forum. Policies that they change, those are interests, it goes to the bargaining forum. Interest is when you want to strike for if I can give an example, strike for salary increases. It's not your right to get a salary increase, it's an interest. That's why it's taken to the bargaining forum and they bargain there, and if there's not an agreement, then they strike. Okay. You've got medical aid. It's a right now because it's part of your condition of service, but should you want to change it, instead now, let's say the university paid for discovery, and you wanted to change it now to NITAS. That's then an interest you have which will go to the bargaining forum. But the right is the university, let's say for example, that they pay only discovery. Okay, does it make sense, the difference? If you come to me with a grievance of interest, I'll frown upon you. Okay. All employees have the right to be represented at grievance procedures. From the start. If you are upset today and you don't want to go to your line manager today, you go to your union. The union has got the right, and you've got the right to go with you to your line manager in step 1. Okay. I know a lot of line managers, when they see the unions, they say, hey, get out, all unions are problems. Colleagues, unions are here to assist the processes. And the faster we realize that unions are here to assist us, you'll see you will have a lot less problems. Okay. So let's say you are aggrieved. Sunny next to me, she kicked me while I walked past her. I'm aggrieved, that's assault, okay, but now I can lodge a complaint, but now the part of that, step 1 is I go and inform my line manager, or she didn't talk to me for a week. Let me use rather that example. I'm aggrieved because she is now being rude. Step 1 is, or the whole purpose of grievance is to have a matter resolved at the lowest possible level. I would have preferred that you first go to person X and say, listen, what is wrong? Why are you not greeting me anymore? What is the problem? But if you can't do that or don't want to do that in terms of the policy, you must go to their direct line manager, your first direct line manager. Not your second or your third, first direct line manager. You'll see even on our grievance forms at the top it says step 2. So if you didn't comply with step 1, I'm going to send you back to your line manager to first to do that. 80% of our grievances gets resolved at step 2 just because step 1 never happened. Okay. Now, do to others what you want to be done to you. You don't want to find out from your line manager, hey, you're doing this and this and this. So that's what I'm saying, communicate to the people. Communicate first and see what is the problem, and then if that person still has an attitude, you go to your line manager. But if you can't, the grievance process is step 1, line manager. It's an informal process, employee relations is not yet involved. I have, however, advised managers, because not all managers have been through the system yet, to invite your HRBP to sit in and just to assist with step 1 process to see, how you can amicably resolve it. So when you see HR sitting there, don't get a fright, it's still step 1, it's informal, but it's just to assist the process, especially sometimes the managers, they don't know how to deal with it. So we say, okay, we sit in once or twice just so that you get the feel of it, and then after that you must do it by yourself. Okay. The step 1, I'll go to the rules now, but should the matter not be resolved at step 1, or you still feel aggrieved after that, your line manager must write, even if it's a 2-sentence, saying, I tried to resolve this matter, but I could not resolve it, so the employee can refer it to step 2. He doesn't have to write a report because it's informal. He just have to say he tried to, but it didn't work. Then step 2, you complete the formal grievance document, preferably with your union. And then that document is submitted to employee relations. The code says it must be submitted to your next line manager, but please, colleagues, submit it to us because we schedule the grievance hearing. Otherwise, if you submit it to your next line manager, they forget about it, your grievance is only heard in 3-4 weeks' time. So if you submit step 2, you can even to both of us, you can submit it to both of us. Then step 2, employee relations will schedule the next line manager to chair. It's a formal process which is being recorded. So afterwards, if you've got any inquiries, you can always ask for the recording of that day and we'll give it to you on CD or DVD. If you're after that step 2, that chairperson, he must give a formal report in writing. He's then going to say, you are right and you are wrong. Which is always, that's why it's always best to resolve it at step 1. You don't want it in writing that you are right or you are wrong. So, but step 2 is a formal, you get a formal report. If you're still aggrieved, then you've got the right to refer it to step 3. What usually happens is step 2, the outcome of step 2, we will scan it in and we'll email it to you. And in that email, we'll indicate this is the outcome. If you're still unsatisfied with the outcome, please notify us within whatever time limit that you would like us to schedule this for step 3. If I hear nothing from you, I say, great, case closed. If otherwise, you write back to me and say, listen, I'm not resolved, please schedule step 3. And then step 3 also we administrate that. We schedule the chairperson, another line manager preferably, and then, which is also a formal process, also recorded, and there will also be a document in writing. If you're still unsatisfied, then I'm going to tell you, yeah, I'm sorry, but we've tried everything. Now please go and refer it to an external party. Our grievance process has only got 3 steps. Okay, so then you can go externally, yes.
Are there ones where person wrote the complaint and then when we got to the hearing, the chairperson asked us to state our case, and then when we started expanding, at some stage he stopped us and he said, but you're talking about stuff now that you didn't write down on your initial complaint. So in that initial document that you draw up, do you have to be very specific about the whole spectrum of what it is that you're going to argue in the hearing? Or have you got the opportunity at the hearing to actually go beyond that which you captured in the document in the first place?
The thing is, you must always consider what is fair to the other side. And remember, just as you want to prepare on documents, they also want to prepare. So at least in your document, you must submit, you must write there, I'm complaining about victimization from my line manager. And the documents, you must just please submit also before the time so that we can give that to them. But you can't say on your grievance you aggrieved about victimization, but then you complain about your salary not being paid last month. Okay, because that's a separate grievance then. So even if you keep your grievance document short, but in broad at least like victimization or that's fine, but then your supporting documents must be given to the other side to also go through before the hearing, which is only fair, just as they will then reply with documents for you to go through before the hearing.
So that would be better to actually be broad in that first
Yes. But don't write 7 pages. Okay. If you want to, I know you academics, you like writing. So if you want to and you feel you want to pour all your emotions out, well, you do that. But you're going to be bound by that. So keep it broad, that's fine. Okay. Yes?
Thanks, Tom. If the two colleagues, the line manager and the colleague, they belong to the same union, can the first step be resolved by the union itself?
No. The first step is a line manager's function. You can call in the union as well, and the union can try and resolve it. But I mean, that's why I say if you are aggrieved, first go to your union. And let the union try to sort it out before it becomes step 1. But if you as a manager become aware of step 1 that someone's put in a grievance, then you need to deal with that. Okay?
So the one-off union would be pre?
Yes. Or what they usually do is you schedule the meeting and then the union will come in and the union will ask you as line manager, can you give us a moment to try and resolve it? And you say, okay, by all means, half an hour, come back, yes, it's resolved. No, okay, let's continue with our meeting.
Yeah, so sometimes it's a problem whereby 2 colleagues belongs to the same union.
Yeah.
Now you as a manager, the very same union that you are paying membership, now it will be only representing the complaining.
No, it's not right. Remember, we don't have only one person in a union. So if you get the rep of your choice. If the union only sends one and the union doesn't want to send someone to represent you, then get another union. Okay.
Another union?
Well, if your union is not representing you, they're not sending someone to represent you, then you get another union, yeah. Because then you get a union who will be there for you and represent you. Isn't that not true?
At the time of the situation.
Well, at the time of you ask for postponement because that will be unfair. But remember, you're also not going to phone the union an hour before your meeting. You're going to see the union once you become aware of the complaint. And so there's this complaint, who do you have to represent me? Then they say, okay, we can have X, Y, Z. What most probably happened in this case is the person who the complaint was about didn't know even there was a complaint or didn't see the union before the time. That's why there was nobody there to represent that person. But then it's the manager's responsibility to say, this is a meeting, you have got the right to be represented. Do you want to be represented or is it your choice to be here alone?
No,
okay.
Actually, look, this person will come with the union.
Yeah.
Immediately I will notice that, okay, fine. I'm also as a line manager belongs to the same union.
Oh,
then
yeah.
I would phone them and say, you know what, since there's this particular case, therefore I request.
No, you as line managers must be very, very careful of when you have a conflict of interest if you belong to a union. Everybody's got the right to belong to a union. I'm not disputing that, but you must decide when you've got the union cap on and when you've got your manager's cap on. You can't be a line manager in a meeting like that and then phone the union, put on your union cap. You can't do that. You're either the one at the stage or the other. It's the same as when you want to institute action against one of your subordinates. Now, do you want a union rep to come and represent you there instead of being the initiator?
No, I don't mean like that. He is a person to deal with the union. But now the union that I'm paid, you know, is the one that will be saying that, look, you have wronged here, or maybe didn't act according to.
Or if the grievance is against you as line manager. Oh, sorry, I still thought it was 2 colleagues. Sorry. So it's against you as a line manager. Yeah, you can contact the union or you can contact ER as a manager and ER will also advise. Okay. But it's your right as a line manager, if the grievance is against you, it's your right as a line manager to have a rep. It is your right, and nobody will at all take that away from you. Okay, so it's just, as a manager, you should be in a position to always prove your rationale behind doing things. And if you've got that covered, then why do you need a rep to advise you? But it's fine, you have got that right. So yes, that's no problem. And then the union, because that will first then come to you, and then if the union wants to interfere and see if they can resolve it, that's fine. But step one has got time limit. So if the union and yourself as the first step cannot resolve it, it still goes to step two. Okay. Sorry, I misunderstood. I still thought it was two employees, subordinates. Any other questions? Can I go to the policy? All right. The aim of a grievance procedure is to create, a channel of employees, a channel for employees who wish to bring any dissatisfaction that they feel on account of an undesirable experience in the employer-employee relationship to the attention of management without fear of discrimination, victimization, or intimidation. The procedure furthermore consists of steps for finding a solution that would be acceptable to both management and the staff members. The purpose is to ensure that grievances are resolved in a constructive manner that is acceptable to both parties at the lowest possible level. And the grievance procedure is applicable to all employees. Please, colleagues, 4.1 is very important. Employees may not at any time be victimized or intimidated for airing grievances concerning seniors, colleagues, subordinates, students, or clients. All grievances must be resolved without delay, within the normal time, and at the lowest possible level. And written grievances must be reported to the ER department. At any stage of the grievance procedure, employees may or are entitled to be represented by a shop steward or a fellow employee if they should prefer. Oh, sorry. And there you see, TUT acknowledges the right of employees to refer any unresolved grievance to the CCMA, should the internal grievance process not fail to resolve the grievance. And if staff members have fears of being victimized or intimidated, he or she has the right to lodge a grievance directly with the Employee Relations Department. An aggrieved employee has the duty to make an effort to discuss his or her grievance with the persons concerned. Do to others what you want to be done to you. You don't want to hear about grievance against you from other parties or from a grievance sitting. So just like that, please communicate it to each other. Employees should not use a grievance procedure to try and remedy any substantive issues. And the Employee Relations Division will grant a staff member an opportunity to air his or her grievance and provide the necessary mechanisms for the resolution of the unhappiness or complaint. Very important, 4.10, the grievance procedure may not be invoked when there is already a disciplinary process against the employee. First come, first serve. If the manager institutes disciplinary action first, that must first be finalized before the grievance is heard. Similarly, if the grievance is started first, then the grievance must first be finalized before the disciplinary action is instituted. Yes, sir.
4.7. Are you saying if I'm aggrieved, like I should come to you and tell you that I've been project?
No, if you're aggrieved against me, then I would recommend that you come to that person, listen, this is the problem. Not that I'm going to put in a grievance. This is the problem. How can we resolve it? Why did this happen? And if you can't resolve it there, then you continue. Okay.
But at least I must talk to you.
Yeah, but sometimes it's not possible. Especially if you've got fear of victimization or that kind of thing, it's not possible. Then we understand it, then you continue. But we always prefer for people to try and first talk to each other. But I know most of the cases it's not possible, but then you start with step one. Okay? And step one, the line manager will inform that person. Okay. Management at all levels should be objective in handling grievances, and each stage of the grievance procedure is bound by time limits. The set period of time, the time periods may only be altered if there's a reason behind that, justifiable reason. Okay. Grievance will be regarded as having been resolved internally when the employee concerned declares him or herself satisfied and signed or after step 3 of this procedure has been exhausted. Now it says unsigned, as I indicated, when we email you and you don't respond, we accept that you are happy. Unless you come and you say you didn't receive the outcome. Okay. There you see 4.15, where possible the line manager must deal with grievances, but the employee relations division should play a facilitating and advisory role. Now, since we've done this HRBP system, I don't know when that started, but the HRBP will take in the role of ER in step 1. ER only become involved at step 2. Okay. The process should allow union intervention between its members before the formal processes start. And an employer must provide relevant information necessary for an employee to lodge or pursue a grievance if requested, and the provision of such information is subject to any limitations imposed by law. This, for example, if I see everybody at the university is entitled when they apply for a position to get the position. Well, it doesn't work like that, but they all have that sense of entitlement. But what will happen is if you want to know, you was not shortlisted but you meet the minimum requirements. So you want to know from HR why they did not shortlist you. Then HR must provide you with documents saying you were shortlisted or not, but this is the reason, or which those are the documents we talk about. But you are not entitled to the CV of the person who was appointed. You know, those are things that you will not be entitled to. Okay. But you can ask for all relevant documents, and that will be given as far as possible. Procedure, verbal complaint, colleagues, is it all right if I don't go through this word by word? But you'll see here the time limits, I just want to go there. 5.1.4, actually, 5.1.3, a staff member who wishes to air a grievance must lodge it with his or her immediate supervisor verbally and on his or her own, or in the presence of his rep within 7 days of the onset of the grievance. We've had people who want to put in grievances about things that happened 3 years ago. It's not happening. Okay. Then the line manager should make a reasonable effort to resolve the grievance within 3 working days, proposing an acceptable solution based on the policy and taking into account the specific circumstances. Then the supervisor's decision should be made known to the employee in writing within 2 working days. And then if you are dissatisfied, you follow step 2. Step 2 is a written grievance. So that written grievance you see here, he or she may lodge a formal grievance in writing within 7 days and copy the ER division in. On receipt of the written grievance, the immediate supervisor should, now we're talking about the second line immediate supervisor. Okay, not your first immediate, it's the second line. He should within 4 working days arrange a meeting to resolve the grievance. And then you'll see the employee's line manager and rep should attend, and any other person who's involved in the grievance. And then if he's still not happy, he should refer the matter to the next level within 7 days. But as indicated, you can just notify employee relations and we will schedule it. So step 3 you'll see is a senior management level, which will be the next line manager. If you are an employee, you report to an HOD. The first step 1 will be to the HOD. Second step will be to the director. Third step will be to the executive or the senior director. Okay, and if you are a HOD who's aggrieved, your first step will be director, then executive, and then the DVC or whoever's on top. Yeah. Now, I prefer a physical meeting, reason being when parties sit there and they talk and they discuss it, then you can see the attitude, you can see the body language, and everybody can, come to an amicable solution to that. But otherwise, if everything's on writing and this one's not happy, and I say everybody, if they can put emotion into emails, it will solve most of our problems. Because sometimes you're in a bad mood and you read this email and then you think the person has got an attitude or a problem, but in the meantime they were just asking a question, and when you read it, you were in the wrong frame of mind.
So say for instance you're at a distant campus,
yeah,
and you have to attend a meeting that's in Pretoria, like for instance, because most of the people, who's paying for your travel and everything?
No, it's department. It's the department, yes. Yeah. So it's the same with the interviews and catering, and even for us if we have a hearing. I mean, it's the department who needs it, because it's your hearing, it's your grievance. So who else must pay for it? Okay. Yes. Yeah.
Two things, just in terms of timelines. So, let's say I sexually harass somebody in my environment, and she or he didn't complain within 7 days. Am I off the hook?
Now you're not off the hook. As I indicated, it doesn't make the action or the reason behind it, that doesn't change that. Okay. But if she waited 3 years, I'm going to seriously frown upon that, and then, you know, that's, you have to look into that.
And then the other question I have is, somebody has been sexually harassed in the workplace, and they reported to their line manager. Sexual harassment is in the disciplinary code. Does the line manager then have to follow the process prescribed by the disciplinary code, or does he follow the grievance process?
No, because it's a disciplinary matter, then they should the line manager should contact employee relations, and as I indicated, we'll go through Priscilla Legetu, will do that. She must first talk to the person, and then from there on, employee relations will assist with the disciplinary hearing. Yeah. It doesn't help to do first the grievance process, because then you have to put this person through this thing twice. So, no.
That's the point that I want to make actually with you, is that we've had that where we had a line manager taking bullying through grievance process rather than through the disciplinary process.
Yeah, I think that is why we're having also this roadshow to try and assist with these things, and this new reporting lines that we worked on in employee relations with TED and Dr. Legetu, we only finalized in the middle of last year. So I don't know when that was, but please now know that this sexual harassment, discrimination, racism, you know, those things, the moment that there's an element of misconduct, we go through the disciplinary process. If the investigation shows that there is merits to take a person to a hearing. Okay. All right. Colleagues, procedure for dispute resolution. Should the employee be dissatisfied with the outcome of step 3, he or she has the right to declare a dispute in terms of the Labour Relations Act. And that is the grievance. I know it's much shorter than the disciplinary code, but believe me, it's got a lot of weight behind it. Okay. So as long as you all know what is your rights and your obligations in this university, then I'm happy. Any questions? Because that's it from my side. Anything else? Yeah.
No, I really just, you know, I've read recently that with the right, there's also a responsibility.
Yes.
And I think that we also should just emphasize. Each person has a right, but there's also a responsibility.
Yes. Yes.
And secondly, what I would like to ask, if, for example, in both cases of the disciplinary as well as the grievance procedure, things are not working out, to what extent can either the persons involved move to outside labour at what stage can that occur? If there's not the adequate protection within them.
Well, with the disciplinary code, when you have a look at discipline, a line manager can't take it externally unless he starts with the grievance procedure because he's not getting the assistance from top management what he desires. Then he's got that right as well. So he can then follow the grievance procedure. But with the grievance procedure, after you followed step 1, 2, and 3, any person can refer a matter externally, all right? But if you see, what I always advise is you put in a grievance. If they don't adhere to the timelines, I remind the person maybe once. I'll put it in and then I'll remind once because that person might have forgotten. But by the second and third time that you have to remind someone to adhere to the timelines and things, then I will refer a matter externally if I was the person aggrieved. Because then it clearly shows that there's either not an intention for someone to schedule your grievance hearing, or management is making a decision at the end of the day. And then always management, when they see a document from CCMA, they're very quick to come to make themselves available for meetings before the time. So it's terrible, yeah. But yes, so I would say a grievance, give the internal process a chance, because if you refer a matter directly outside, The first thing I'll ask you at the CCMA is, why did you not come to employee relations to try and assist with this matter? But if employee relations is failing you, if human resources is failing you, if the vice chancellor is failing you, then no other alternative but to refer a matter to CCMA or somewhere else. Okay? But please, you must always just first give us a chance. We get a lot of cases that we could have resolved internally where the people just went to CCMA directly. And they refer it back to TUT. So the CCMA is not going to listen to it, they refer it back. Okay, you must give the processes a chance. And it's good processes. If the people, the managers, they deal with it correctly and they make use of it properly, it's good process and procedures that's only going to assist the university. Okay, anything else? Thank you. Then I'm done. Thank you.